Just kindly to mention one application, one read application, move it on urgent, which is tomorrow. This is against an order passed by the SDO for cancellation of my caste certificate. Now the SDO relies upon a preliminary inquiry report of the video. That copy has never been served on me. And now they are relying on the report and saying if you don't participate in the hearing tomorrow, we will cancel your certificate. I should kindly that.
Not tomorrow. Let it appear next week.
The date of the hearing is tomorrow, Your Lordship.
Doesn't matter.
Happy will move expiry. Your Lordship, kindly see the just one sentence from this.
No, come on Monday, 18th. Come on Monday, serve notice. 18th, leave. Yes?
May I have a Lordship's kind leave to mention, my lord, item 1415 of the monthly list. My lord, the district election officers, that is the DM and the SDOs, are implementing the impugned order in the writ petition, my lord. But if it is implemented, my writ will become infructuous.
Why was it not mentioned on the day of mentioning?
My lord, it has been mentioned, my lord, on Mondays. My lord, previously also in last month also it was mentioned, my lord.
No, then it will appear. They can even mention koreche kina.
May I have your
Lord,
Give the number.
My lord, 1415.
Check up.
May I have
check
your
up.
Lordship kind leave
Yes.
to mention, my lord.
Kindly the upgraded motion, my lord, if it can appear.
Yes, upgraded. If it has been mentioned for upgradation, slip is not required to be handed.
My lord, interim order is expiring on 14th of August, my lord.
Give.
My lord, may
Serve
kindly.
notice.
I have already served ISL against you.
Yes, do.
My lord, may kindly permit me to mention one matter. In today's list, it is appearing as 103. My lord, due to the pendency of the criminal proceedings, my lord, the petitioner is being stopped from getting the renewal of the passport. My lord, there is an NOC from the learned trial court who has given the NOC and asked the petitioner to apply to the passport officer. Now they are saying that no, that will not work. And my lord, the trial court is saying that we will not do anything else. My lord, kindly hears it, my lord.
Item number 103.
10. My lord, kindly keeps it to
Upgraded motion on Monday.
my
Serve
lord,
notice.
not on Monday, my lord. Any other than on 8 other than 8.
Tuesday.
My lord, grateful, my lord.
Tuesday. Serve notice.
With your Lordship, may I be permitted to mention
Slip is not required. Slip is not required.
item number 286 of today's list, my lord. This matter was lastly heard by your Lordship, my lord. This matter pertains to an LOC issued in my name, my lord. Your Lordship had passed an order that this matter will appear today in the list. Appearing, my lord, it is at the bottom 286. I was only praying, my lord, since there's an LOC issued and my lord, there's an urgency for me to go outside India for some purposes. My lord, a report was called, my lord. Report is filed, served upon us. We've given an exception, my lord. Only if it could be heard out, my lord.
Do not mention, it will be heard out in usual course. Yes.
This is for contempt application.
What you want?
Against the last order, my lord.
What you want?
My lord, for inclusion of contempt.
Today is not the day for inclusion. When inclusions are taken, please mention. Yes,
My lord,
ma'am.
may I be permitted to mention, my lord, for proposed correction, my lord, of the order dated 23rd July 2025, my lord.
What does proposed correction
My
mean?
lord, correction means, my lord, page number 2 of the order dated 23rd July 2025, the court does find, my lord, instead of does find, my lord, it would be does not find.
Oh, very well. Give.
My lord kindly recalls that OCI matter, two children's got stuck, exit permit not given, but that matter is appearing in item number 63.
Yes.
But that was supposed to come under, my lord, to be specially fixed, urgent motion. But that has not come, my lord. 63.
Who is your other side?
By Mrs. Priyanka Tebriwal.
Give a notice. Come back. Let me see.
Lordship, grateful.
Yes.
Two tender matters. Lord, on the similar ground, Lord, these are tenders for supply of solar power plant and solar power pump. Well, with regard to the solar power plant,
No, what you want?
I tell you, Lord, similar last tender, I was the L1.
Mm.
Lord, last 10 years document I have annexed. This year, the government has introduced a new clause. They are saying that I must have a trade license from Bengal, must have a GST license from Bengal. This clause was never there in the last 10 tenders. This is to oust not. I am from UP. I am a company from UP. I am one of the most not eligible candidate. They are to oust me or oust from participation outside Bengal. It's a supply of solar power plant, Lord. They are introducing these clauses which are non-essential. And now nobody apart from Bengal, Lord, can participate in this.
So where is the problem?
Lord, the problem is that it is cutting my right to participate in the bidding process, number one.
No, it is for
Lord,
the file it in the department.
Lord,
No, not on
14th
merit
is-
now.
Lord, 14th
All the
is the last. Lord, 14th is the last date.
You file it in the
Lord,
department.
I will file. Allow me to file for 14th, Lord. Otherwise, the department will not accept it.
You will
Lord,
file.
the
let
department
us
will
see.
not accept, Lord, apart from if I file it, Lord, giving date of 14th. It
Today
takes
is
3 days.
12.
Takes 3 days
14
time.
days notice is required.
70
So it
hours
goes
notice
to-
now, they will say, Lord, allow me to file it on 14th, Lord, only that leave I am asking. Otherwise, I will not be able to file it.
All right.
Yes, only that leave.
14th.
Yes.
Yes.
14.
Item 1. Petitioner is here.
This matter went before the Supreme Court.
Went to the Supreme
Yes, my lord, the stay was granted. My lord, we had the information. It was informed to your lordship on the last occasion too.
All right.
And my lord,
Yes, it is
just-
pending before the Supreme Court.
since my lord, the
Any final order passed?
final one, not yet. My lord, the last information. Kya ache last time? 14th तारीख, 14th August.
14th August it is fixed.
Tentatively,
All right, please come. It has been brought to the notice of the court that the issue is pending consideration before the Honorable Supreme Court and is listed for consideration on 14th August. So, in view of such submission, release the contempt application on 10th November. None for the petitioner.
Should I appear on behalf of the petitioner? My lord?
Yes.
I have filed the affidavit of service.
Yes.
Apropos your lordship, the directions, my lord, the placed contemner as also the advocate record for the KMC have been served.
It's all right. The order has not been complied with.
Yes.
May I kindly come to page 6 of the contempt application.
Yes.
Your petitioner being aggrieved about the illegal construction at premises number 32 and 33 Ismail Street. I am stopping here for a moment. May I kindly come to the bottom portion, the read in the nature of mandamus and in respect of premises number 32 and 33. Next page. That is also in respect of premises number 32 and 33 onwards. But I am not further going. Now, may I kindly see my report.
What is this?
Corporation instruction.
Where is the order? What happened to 32? 32 and 33 merged, or what has happened?
32, there is no premises as 32. 33 is a vacant land. Now that has been stated.
Yes, I can see that.
Yes, but there is no premises known as 32 and 33 is vacant. But
Yes.
the order which is impossible to comply, but no contempt lies.
Yes.
Your lordship, we kindly come to page 101, my lord, of the in volume 1, my lord, of the contempt.
Yes.
It says
This
that-
was in 2003.
it says that, my lord,
Premises number 32 and 33.
has been mutated in your name, my lord, necessary book correction and other work will be
It's,
done.
sir, this is of 2003. We are in 25. What has happened in the meantime to the premises number 32? Has it been amalgamated with some other premises?
I have no, my lord, no instruction.
In the corporation, there is no.
In your lordship's order, my lord, in the writ petition that to give a hearing, is a representation, so filed along with the documents in support thereof, my lord. Nothing has happened.
Everything has happened. Your client is not cooperating.
On 9 July, a notice of hearing was given, my lord. Thereafter, nothing has happened, my lord.
The 9th July hearing, did your client participate?
Yes, my lord. He was asked to produce a letter of authority, my lord. That was produced. Thereafter, 5 representations were made, my lord. Nothing happened. Then advocate's notice was issued, my lord.
Yes, advocate's notice. Show me that 32 premises number exists. Show me the existence. Tell your client to show the existence of premises number 32.
Corporation can say, my lord, corporation records has to be called for.
Corporation record says there is nothing. There is no premises 32. And 33 is a vacant land. Show me the picture of the unauthorized construction.
Kindly see these 2 documents. We have issued a letter to him. Kindly present at the site joint inspection. They refused. Practically, kindly see.
Joint inspection has nothing to do with your lordship's order, my lord.
Why?
How can I say, my lord, who are the occupants?
You show the unauthorized construction.
I have no access to the building.
Building?
Yes, my lord, 30, the multi-student buildings are
30?
33 Ismail Street, my lord, the buildings have come up, my lord.
33 Ismail Street, there is a building standing?
Yes, my lord.
Show me the photograph.
My lord, this is a letter of the Thika authority that premises number 33 has been declared as Thika property with effect from 1982. My lord, kindly see. This is the letter.
You file an affidavit, let him deal with it. Please come.
My lord, in that event, your lordship will kindly give me leave to file a supplementary affidavit. Your lordship has asked for this thing, photographs. I will enclose all the things, my lord, in the supplementary affidavit.
A report signed by the engineers of the corporation on 6th August 2025 is placed on record. Stop. Let an affidavit of compliance be prepared and circulated by 26th August 2025.
Affidavit of compliance with this order.
Annex this and the documents, and you show that it is not possible for compliance. That is enough compliance. Achha. By 26th, release the matter on 9th September. It will be open for the petitioner to file an exception to the affidavit.
And also, my lord, affidavit, my lord, I will just annex bring on record, my lord, the subsequent developments, how the building.
In the exception you bring.
May I take back those 2 documents?
Yes.
Report, your lordship.
Report টা
Please
রেখে
to keep
দেবেন।
it on record.
আর এই দুটো ফেরত।
I'm for the petitioner. My lord, I am for the petitioner. My lord, kindly, my lord, give us 2 more weeks.
I'm grateful to that.
Your lordship, my lord,
2
by an
more
order,
for?
my lord, by an order of 9th July 2025, your lordship had, my lord, directed the railways to allow me inspection of my own supplied products.
Yes.
My lord, on the 7th, we are following up with them. On the 7th of August, my lord, the railways has written to us requesting us to intimate a time and place of our choice. My lord,
For inspection.
for inspection.
And you have not yet intimated.
No, my lord. So, my lord, we will, my lord. Kindly just give us, my lord.
On the prayer of the learned advocate representing the petitioners, hearing of the writ petition stands adjourned till 9th September.
My lord, there was a direction, my lord, for the railway to file a report on the inspection. My lord, by today, my lord, your lordship may consider extending that time.
Yes, yes. Let it remain in the list.
Very well.
Let's see.
Grateful.
Happy for the petitioner.
Yes.
Well, this writ petition is for grant of incentive under the West Bengal incentive scheme. For special package of incentives.
I can see a recording that a matter is pending, similar matter is pending before the Honorable Division Bench.
What may I say? There are, for this particular incentive, for few years, Lordship, already there is an order passed by a coordinate bench by which my prayer has been allowed. Against that, they have preferred an appeal. 2024 till date,
Nothing.
No stay, nothing. For the balance year, my lord, we had filed a writ petition in the past. That writ petition for the purpose of grant of certificates from the sale tax authority. Lordship, they conceded, gave us the certificates. Thereafter, my lord, they did not grant us the incentives. Lordship, that is why the writ petition. So my contention is they have already, Lordship, admitted they are stopped after grant of certificate. They cannot any further contend. Anyway, their appeal, whichever they will, they are not moving it. They're not
Yes,
interested.
what is your
Then there is
submission
no stay.
with
My lord,
regard to
for
the appeal?
WPIs.
Yes,
My lord, first of all, my lord, in that appeal, their submission was there is a new statute has come, which is called revocation of all incentives. That should be disclosed. We have prepared the supplementary. Thereafter, my lord, change of determinant, the matter did not come up. It was fixed in a particular day.
yes.
My lord, kindly, my lord, allow us 2 weeks time. We'll come the division because my lord, this is an understanding. They will not proceed with the contempt, and these are the situation.
Contempt with respect to
My lord,
that,
there is
that
one-
proceeding.
They have also, my lord, if today, my lord, the same issue is pending before the division bench, whether were entitled. My lord, our case was there is an amendment. They had not complied with their preconditions. That is our case made out. My lord, that is allowed. Everything goes.
Regarding the revocation of the incentives, that is the new act.
No, my lord, they have
Is-
said. My lord,
Is any bill pending?
but they had said we state should disclose that fact.
No, it's not in this matter. I just want
Others
to
matters are
inquire.
in one matter. My lord had passed an interim order recovery. There should not be any further recovery, but did not interfere with the other parts. There is already there are
No, any bill pending or anything of that sort?
bill
Bill.
is not pending. Writ petition before my lords. There are 5 and 6 writ petitions.
All right, please come.
Lordship, if I may say that, Lordship,
Mm,
they want to say, take in the garb of the pendency of the appeal, they
No,
want
it's
to
not a
delay
garb
this
of-
writ petition.
There
But
is
Lordship
nothing in the
grants
garb
them a
of-
last
there are
chance to
something-
obtain a stay order.
There question of statement. It was an understanding. It was heard on they said we should disclose this revocation.
Where
act.
we
But
cannot
they
proceed
said
with
that-
our suit, our contempt application because of
the
their delay. Suit
appeal before the Honorable Division Bench is yet
suit
to be disposed of. Stop next. List this writ petition for further consideration on 9th September.
as a last chance, my Lordship.
Your writ will remain pending, last or first.
Last. I'm grateful.
I'm grateful.
My lord, I am for the petitioner, your lordship. Directed to
Produce the
direct me to take instruction. I have taken instruction. The petitioner is satisfied upon getting the
Very well.
certified copy.
The grievance of the petitioner has been redressed. Stop. In view of such submission, the writ petition stands disposed of. Next.
My lords, I appear for the petitioner, my lord, in this matter. My lord, the challenge in this application, my lord, was directed against, my lord, the action of the bank in issuing a notice of personal guarantee, invoking personal guarantee in 2025. The point here being, my lord, it's barred by limitation, my lord, they don't have the jurisdiction. Lordship was pleased to pass an order on 21st of July 2025, by which, my lord, a report was called for from the bank in the form of an affidavit disclosing, my lord, particulars of the dates, my lord, till date, dates and figures. We have not been, my lord, served with a copy of we that report. served an email. I have a copy of the email, my lords. My lords will kindly see the email copy we served.
Give a copy to your learned
My lords,
friend.
I'll give a copy, my lords, before the report is
Yes.
served. My lords, there is one issue with the report. There is a wrong annexure in the report. It's the same guarantee agreement. There are two petitioners, the father and the son. In my pleadings in the report, I have mentioned as the guarantee agreement of the father, but the annexure is of the son. The terms, conditions, everything is the same. That is the
Let
only
them
thing.
correct it
Proper
and send it to
annexure.
me. Put in the proper annexure and forward a hard copy to your
I will,
learned friend
I will, my lords.
and a copy to the court
My lords,
also.
I have the original right now, but my lords, I'll modify the
Please do.
annexures. My lord,
And
in that
you
case,
can
may I
file an
request-
exception also.
To the
Yeah.
report, yes. You could just mention your number or email.
Learned advocate representing the bank seeks extension of time for filing the report. Next. The time to file the report stands extended till 26th August. Stop. Let advance copy of the same be served upon the learned advocate for the petitioner by 14th of August. Stop. It will be open for the petitioners to file an exception to the report prior to the adjourned date.
My
List
lord,
on
may I only
26th.
pray for this, my lord? Instead of 26th August, may I pray for a shorter date. Only the reason being, in the meantime, after the Lordship's last order, they have filed a Section 95 proceeding before the National Company Law Tribunal. The only issue before your Lordship was whether they could have invoked the guarantee. Now, if Lordship is with me on the issue of limitation, my lord, no further steps, my lord, because this is a step in furtherance of the invocation. They could not have, my lord, instituted the proceeding. So, my lord, first, my lord, they take time to file a report, and then they, my lord, seek an extension. In the meantime, if they proceed before the NCLT and the
20th, যেটা 26 বলেছিলাম সেটা 20th.
grateful, my lord.
Grateful.
20th.
I need to appear for the respondent bank, and I am for the petitioner, my lords. What had happened, my there was some disputes and differences between my employer and employee for employer, my lord, and for which my salary
Disputes and differences
between my employer and me, for which the salary was not credited to my account for some time, and at one go around 1,45,000 was credited to my bank account. Immediately thereafter, the bank seized 1 lakh rupees, my lord. In fact, the bank himself writes an email to me that they have Lian, my lord. Lian comes later, my lord. First the take away 1 lakh rupees from my bank account. I immediately take away, simply take away. I go before the banking ombudsman. It is immediately credited back, for which that banking ombudsman complaint becomes infructuous. Thereafter, after it is credited back, a lien is placed on the sum of rupees 1 lakh for reasons best known to the bank. I again go before the banking ombudsman. Banking ombudsman, for some reason, closes my complaint under section 16(2)(a) of the ombudsman scheme. I'll just show the case status. That is at page 30, my lord.
closed,
And it is under section 16(2)(a) of the ombudsman scheme. May I just hand over the scheme?
Where is the section mentioned?
Yes,
page 31. Clause. Yes, 16(2)(a). Yes, what is there?
Just hand over the scheme.
Copy down.
Section 2(a), my lord. Rejection of complaint by section 16, my lord.
Compensation sought for is beyond the power of the ombudsman to award. You sought for compensation.
My lord will kindly see the case status, what I have sought for. My lord will kindly come to page 31. Complaint subcategory 1, savings bank. Complaint subcategory 2, debit fees lien marked, put on hold. This is the case status. So this is not compensation, but I have been my complaint has been closed under section 16(2)(a), which says that the ombudsman may reject a complaint at any stage if, in his opinion, there is no deficiency in service. So how does this opinion come from, my lord? There is no reasoned order, and this is the only case status.
You want the bank to take away the lien?
My lord.
Nothing more?
Nothing more.
Reason?
As of now, I have gathered, he has a ABELA credit facility, that account has become NPA. That's why, what has happened?
File a report.
File a report,
Yes, please come. The petitioner seeks for a direction upon the Punjab National Bank to remove the lien that has been created over a sum of rupees 1 lakh in the bank account of the petitioner. Paragraph. The bank is directed to file a report by way of affidavit by 26th of August, 2 weeks. List on 9th September. It will be open for the petitioner to file exception to the report prior to the adjourned date. You can take this back. On the next day, you can keep it.
Your Lordship, we are led by Senior Advocate Mr. Vipul Kundalia. We just asked for a short passover. He's downstairs. He'll come in a minute.
Let him start in the meantime. You are here. All right. Yes, what is it?
Yes. And the last occasion, my lord, directed to serve afresh. My lord, I have done.
All right.
It's not possible to get the track reports, my lord.
All right, they are appearing.
Yes. My lord, I am seeking for setting aside the impugned order, my lord, annexed at my page 88. But kindly comes to the impugned order once, then I'll brief your lordship about
88?
88.
Yes, please.
And the order is at 89.
All right.
Madam, reading the applicant statement, that is the order, and the decision is as the below. I am reading the decision. The committee went through the statements made by the firm and discussed the matter at length and observed that the applicant has not submitted any cogent reason justification in support of any genuine hardship. And I am focusing on this word, my lord, genuine hardship faced by them. Accordingly, the committee decided to reject the request. Now I am coming to the case. I have exported sugar to Bangladesh. In the year 2012, the order was given by the DGFT. Now, right after that, I sought for the duty entitlement, which is as per the statute. The 4% of the total order amount will be entitled by the petitioner. Now, my lord, the final assessment report was published. That is at page 56, my lord. Based upon this, my final assessment is made.
Page 56.
Yes.
Yes.
Now, again, my lord, I am reading the actual area, my lord, 61, page 61, paragraph number 13.
Yes.
Following the ratio decidendi of the above judgments in the instant case, it can be said that mere technical lapses in documentation, if any, as per stipulated conditions of para 2.34 read with para 9.62 of FTP 2009-14 is not tantamount to violation of FTP 2009-14. I find that Messrs. Nagrika is the petitioner, my lord, also may be treated as the third-party exporter in the instant case of export vide 4 bills of export and is entitled for applicable benefit arising out of the said export. Now, my lord,
Where did you read? Page 61?
Page 61 at the
Paragraph
para
13.
Yes.
All right.
And para 62, my lord, the last line.
Yes.
Also may be treated as the third-party exporter in the instant case of export vide 4 bills of export and is entitled for applicable benefit arising out of the said export. Now, that is my case. After that assessment report was published in the year 2022, I applied before the PRC for my duty entitled. They straightforward rejected it because of there is no genuine hardship. But that cannot be done. This is a statutory benefit, my lord. I am entitled to it. Now, kindly comes to the impugned order once again, my lord.
For me, there is a provision where the hardship issue is to be taken up for consideration by the authority for the purpose of this grant. In the scheme itself, it is there. All right, let me hear once. Are you there?
Lord, I'm led by Mr. Bipul Kundal. We are appearing in response of 1 to 6, my lord.
Yes.
My lord, only, my lord, yesterday, my lord, we got the brief, my lord. My lord, we need, my lord, take I'm led by Mr. Kundal.
Yes.
Last
My lord, before that, probably I have the determination issue is also there.
This bench doesn't have determination?
Go before group 4. My
All
lord.
right. Taxing matters?
Yes, my lord. We'll see customs is also there.
All right.
Your ladyship will see this judgment.
Why?
There.
Judgment for what?
Just for there's one similar kind of
issue.
No order in which it was held that it will go before the revenue.
Customs bench? Very well. Learned advocate for the respondents raise objection with regard to the consideration of this matter by this bench. Stop. It has been submitted that the matter ought to be dealt with by the bench taking up Group 4 matters. Stop. Next. In view of such submission, hearing such submission, the matter stands released from the list of this bench. Stop. Let the same appear before the bench taking up Group 4 matters.
Great. Great.
Presentation form change করে leave the name.
Well, kindly grant me leave to change the presentation form.
All right. Leave is granted to the learned advocate on record of the petitioner to amend the presentation form and the front sheet of the writ petition.
Well, I appear for the respondents. There are two the contempt petitions and also the writ petition which has been assigned before losses, my lord. I am filing the opinion of petition on the last occasion. It was directed that immediately to the writ application because in fact, my lord, nothing to be adjudicated. Rather, my lord, on the contempt application, if the writ application is finally decided, because they have sought to challenge that order passed under section 4 and subsequent 8 before losses, my lord. And the demolition case was the answer, the contempt petition was that you will be directed to deal with and ultimately dispose of the entire issue. That was clarified, but ultimately now the situation is that writ petition is before lordship that is to be finally adjudicated. But the last occasion is directed and filing the opposition.
And a copy may be given, my lord, directed on the last occasion that it should be circulated between all the parties.
It has not been circulated.
He is the respondent. Well,
where is the petitioner?
Petitioner
is not there, but I am the petitioner in item number 9. The contempt application.
The contempt petitioner.
Petitioner in the contempt matter. And where is Sri Sham projects?
Your Lordship, I'm appearing for Sri Sham projects. Yes, I'm led by Siddhartha Banerjee. He's appearing. He's on legs in courtroom 24.
Yes. So, you proceed with the matter?
I'm praying for a short passover, Your Lordship.
Passover will not be possible. Why don't you proceed? Why don't you proceed?
I don't know that they have used the reply because
there was the copy served upon the.
So far as the opposition is concerned, that has been served by 18 July.
Oh,
18 July.
Served upon me also.
All right, let a copy of the affidavit in opposition filed by the corporation be served upon learned advocate representing Abhishek Mishra, the petitioner in the contempt application. Stop. Accommodation has been sought for on behalf of the learned counsel representing Sri Sham Projects Private Limited. Stop. Next. Let hearing of the matter stands adjourned till 9th September. Stop. It will be open for the petitioner to file a reply to the opposition filed by the corporation in the writ petition.
You conclude that 9th September because it is open and short case to
yes, very
আচ্ছা এই অপোজিশনটা আজকে দিল তো এফিডেভিট অপোজিশনটা তো রেকর্ডে রাখাই হয়েছে
in the KMC report itself is they have already said that illegal
and whatever the points they have taken
the illegal
unauthorized construction is there.
Yes, major whatever the points they have asked the 408 that has been decided by the up to the division bench having regard considered losses order also.
Yes.
Next. ইলেভেনটা কি হবে ঠিক আছে তাহলে এটাকেও লিস্ট অন 9 সেপ্টেম্বর করে দেবেন ওটা কিসে দিল এখানেই কিন্তু রিটটা
I appear for the respondent number 2 in this matter, madam.
Yes.
This matter has been adjourned for some time now. Issue was with regard to, my lord, jurisdiction, my lord, of the MSME Council. 2 points were being urged by Mr. Bachawat initially. Whether it's, my lord, a registration certificate prior to the date of the contract being awarded in favor of my client. And the other point was whether a works contract, my lord, being a works contract, whether it would be, my lord, ousted from
my lord.
purview of the, my lord, MSME Council's jurisdiction. These are the 2 issues which he was raising. Now, there's an order in a section 9 proceeding as well, which says, my lord, conciliation can continue, but it will not thereafter, if it fails, go to arbitration. That's the order which is subsisting. It's for the my lord, affidavits are complete.
Affidavits are complete, my lord. My submission, my lord, before this honorable court is, my lord, the issue whether works contract, the issue whether whether a works contract would be covered under the MSME Act, my lord. There are conflicting judgments of various high courts, my lord. Some judgments say that a works contract would not come under the purview of the MSME Act, and some judgments say works contract may come under the purview of the MSME Act, my lord. This honorable court, my lord, in one of the matters passed an order stating that no, so far as the works contracts are concerned, that would come under the purview of the MSME Act. Against that order, there's an appeal which is pending before the division bench. That is,
I adjourn it.
no, that, my lord, these submissions were made before your lordship, and your lordship at one point of time had directed the matter to go out of the list also.
Yes.
Now their contention is that it is not pending before the division bench.
All right.
So that is the reason.
You say that it is pending?
Yes, I say it is pending, my lord. I have the compilation of 2 sets of orders. One sets of orders passed by that court, that order which said that MSME Act, the works contract would come under MSME, and appeal against which is pending as of date. I have the entire order sheet of that compilation, my lord, and that order which I am referring to, where the division bench has, where the matter is pending before the division bench, refers to an SLP. That SLP is also pending as of date. So I have compilation, my lord, of both the sets.
And the SLP arises out of order passed
by Calcutta High Court. By the Honorable Calcutta High Court. The matter was initially passed by the single bench, went up to division bench.
And
against
then
that order, it is pending before the Supreme Court. Now, in the Supreme Court, what happened, my lord? In January 2025, since there was conflicting judgments of the Supreme Court also,
yes,
the issue was determined and it was referred to a larger bench. Now, that larger bench reference is pending. While that is pending, my lord, several orders from several high courts have been tagged there, my lord, are being tagged constantly, my lord, and the issue is still pending. That is my submission. Now, I am led by Mr. Bachawat, my lord. I have all the papers with me. I am led by Mr. Bachawat, my lord. May kindly allow him to make the submissions in case they oppose to this prayer, my lord. That is my only prayer. And the interim order as of date, the conciliation proceedings are still on. So whatever interim order I have, there can be no prejudice which is caused to them. Because until conciliation proceedings are over, the question of arbitration would only arise once conciliation is over. Now, if the MSME authority is not giving a date since October, that cannot be on my account. I am participating there. It is not their case, and it is not MSME's case that I am not appearing there.
Why are dates not given?
That, my lord,
no idea.
No idea, my lord. We were asked to file a compilation of whatever documents we wanted to rely upon. I have done so, and I have served it upon my learned friend's client also.
All right.
We have also filed a compilation. Last date we got was September 24. Now, because of the
So he says it's September or October 24.
September or October 24.
Thereafter, nothing has happened. Then what can be done right now? Please wait. Please come.
My lord, I was being led by Ms. Bhuturia, my lord. If lordship kindly hears her for a
Your Lordship, if your Lordship considers the judgment of the Supreme Court, which has been passed in January 2025, that judgment, your Lordship, only refers the question as far as if the registration is not there and the claim has been submitted, your Lordship. In this case, your Lordship, the registration was prior to the contact date from 2015. As far as works contact is concerned, if your Lordship sees the judgment, your Lordship, that matter has not been referred to the larger bench, and in fact, the court holds, your Lordship, that the supplier will include everyone. A party would include everyone, not only the supplier. If your Lordship will kindly have a look at that judgment, your Lordship. Because, your Lordship, as far as registration is concerned, your Lordship, that's not the question, your Lordship. Our registration is from 2015. That the MSME Council can very well look into it, your Lordship. And we have also disclosed the documents to show, your Lordship, that our registration is from 2015.
All right. Right now it is at the conciliation stage, right? So let the conciliation proceeding continue.
Yes,
thereafter, we'll see what is to be done.
But your Lordship, the conciliation proceeding also was in the last date was in September, your Lordship.
Oh,
Nothing has happened thereafter, your Lordship.
What can be done?
We directed, my lord, to at least proceed with the conciliation. There's no embargo.
In his petition, the court will not direct. Please come.
Your Lordship, if your Lordship considers, your Lordship, the interim order passed, your Lordship, wherein that conciliation has been provided for, if your Lordship kindly considers that.
Is reported to be ongoing. Stuff next. The similar issues appear to be pending before the Honorable Supreme Court. আচ্ছা এটাকে লিখবেন learned advocate for the petitioner submits that similar issue is pending consideration before the Honorable Supreme Court. Paragraph. The parties are directed to follow up the matter with the conciliation officer. Stop. Adjourn till 9th of September.
My lord, the interim order may be extended in that event.
The interim order that is subsisting is extended till 19th of September 2025 or until further order, which is what it's earlier.
Very grateful, Your Lordship.
Again, my lord, I'm led by Mr. Shumidava Chakraborty, my lord. He could not come today, my lord. I'm praying for a not today, my lord.
What is the matter?
My lord, I'm not accosted with the facts and circumstances, my lord.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner.
My lord, I appear for the 13.
Item number 13.
Petitioner?
Oh, no. I'm sorry, my lord. I'm sorry. I apologize.
Acha, accommodation sought. List on 16th September.
Grateful, my lord.
Give your appearance, please.
My lords, may I please, my lords? My writ petition, my lords, seeking quashing of certain letters issued by respondent Calcutta Stock Exchange, my lords, whereby they have threatened to, my lords, freeze my depository accounts for non-payment of annual listing fees and, my lords, non-compliance.
Is listing done by the Calcutta Stock Exchange anymore?
Not existing, my lords. Whereas there's an order of the Honorable High Court asking them to square off the derivatives and close shop. My lords, and there are further notifications and newspaper articles also where they've been given the ultimum to close shop, my lords. Now, my lords, however, my lords,
my learned friend is not
no, my
appropriately
lords,
instructed in that regard.
very well.
I'll hear you.
My lords, I'll just indicate as to why, my lords, these letters whereby they are threatening me to freeze my depository accounts for non-payment of annual listing fees is, my lords, wrong and cannot be issued because, my lords, the standard operating procedure regarding actions to be taken for non-payment of annual listing fees has not been complied with, my lords. My lords, may I just, and my lords, your lordship,
Formalities to be complied.
I'll just show to your lordship. My lord, prior to that, I'll just indicate there was an interim order also passed in this matter. My lords,
Alright, show me the formalities.
Yes, my lords. May I just show your lordship the SOP? My lords, may kindly take my supplementary affidavit, my lords. Page 22 of my supplementary affidavit. Page 22 of my supplementary affidavit, your lordship. 28th November, my lords, there was an interim order asking them not to freeze my account.
22
of my, my lords,
yes,
supplementary affidavit. My lords, this is a note. This is the standard operating procedure regarding actions for non-payment of ALF, my lords, dated 11th February 2021. Now, my lords, I'll not trouble your lordships and take you to the relevant clauses straight away. My lords, we kindly come to page 25, which is clause 6. Now, my lords, as per this,
yes.
As per this clause 6 and 7, my lords, 7, your lordships will kindly take the actions under the SOP shall be taken where invoices for ALF have been raised annually and shall be applicable for the invoices raised for the financial year from the financial year 2020 to 2021. So, my lords, in my limited understanding, they cannot claim any ALF prior to the year 2020 and 2021, and in order to claim ALF after the year 2020 and 2021, they have to raise invoices annually. Now, my lords, in my cases, my lords, both these situations have not been complied with. My lords, may kindly take their affidavit in opposition, page 50. My lords, they are claiming ALF from the year 2014. So, my lords, as per clause 7, they cannot claim till the year 2014 till 2020.
What is going to happen for that period from 14 to 21?
Kindly take clause 6.
Yes.
The above SOP is applicable with immediate effect and supersede all the notices June 11, 2019, November 6, 2020 previously issued by the exchanges on the subject matter. So, my lords, they go away. And, my lords, accordingly, no further action shall be initiated by the exchanges under the said notices and circulars, my lords. Now, my lords, this is from 14 to 20, my lords. If they were eligible to claim, my lords, they could have done in the previous notifications, not under this notification. Since they
So
are
the
not
previous, there is a previous notification.
which has been superseded, my lords. By
Maybe superseded
My lord.
from a particular date, but prior thereto, there must be some listing fee which you are required to pay.
my lords,
Not in terms of this SOP,
yes, my lords.
but in terms of the
Yes,
SOP
so
which
those-
was applicable.
Plus, those SOPs are also there, my lords. If my lords is not convinced, my lords, the second limb of my argument is, my lords, no invoices have been raised.
Yes.
Now, my lords, your lordship,
Raised from the financial year 2021.
prior to that also, my lords, in terms of the
Prior to-
previous circulars also, no invoices, my lords. Kindly take
Alright.
page 50 of their affidavit in opposition once, my lords. And my lords, I'll show to your lordships the provisions for raising of invoices also. They're categorical. My lords, may kindly take page 50 of their opposition.
Yes. Suspended on 21st of March 2014.
my lords. Now, my lords, may kindly see page 50. My lords, they are claiming.
1 minute. What does this suspension over here mean?
My lords, this is in terms of clause 4 of another notification, which enables them to restrict my trading, my lords, in the event I am in non-compliance of the circular or the regulations of LODR. Listing regulations, my lords. Now, my lords, may kindly take page 50. My lords, this is the only document which they have given to claim this money. There is no invoice. Now, my lords, kindly, and my lords, prior to this, they rely upon one more document to say that we have intimated you. My lords, kindly see, that is at page 39.
Page 50, when was it supplied to you?
In the AO, my lords.
In the AO for the first time.
Now, my lords, page 39. With 50, page 39.
Yes, please.
My lords, page 39. This is of 29th January 2024.
Yes.
They indicate that you are required to pay a sum of rupees 3,80,000 towards, out of which 276 is towards listing fees and 49 is towards against taxes against listing fees, and my lords, 26,000 is against interest. Now, my lords, no invoices. Now, my lords, may just come back to the circular ones. My lords. Kindly take the circular ones, my lords, which is the SOP, my lords, at page 22. My lords, kindly now come to page 22, my lords, 22, my lords. Kindly come to clause 3, my lords.
Yes.
My lords, the SOP against listing entities for non-payment of ALF shall be as under. Stock exchange shall not initiate any punitive measure on non-payment of ALF till 6 months from the date of issuance of invoice of ALF raised for that year, my lords. Now, my lords, 14 to 24, first time I have been intimated by an email dated 29 January 2024 that for 10 years I am supposed to pay this listing fees without any invoices, my lords.
What was your expectation that you'll be listed without paying a fee? Is it free?
No, my lords, that is not my expectation.
What is it?
Now, my lords, the fact of the matter is, my lords, this SOP has not been complied with, and my case, my lords, subject to what your lordship feels, my lords, this is an attempt to unjustly enrich themselves before their shops are being closed. Let's kindly take the notifications, the date of the notifications, the passing of the order by the Honorable Division Bench of this Honorable Court asking Calcutta Stock Exchange to close shop, my lords. So all of this has happened, my lords, from the date of the order of the Division Bench of the Honorable High Court, which is dated, my lords, 16th November 2023. After that, my lords, the first letter has come to me on 9th November. The first letter has come to me 10 days prior to the High Division Bench order on 9th November. That is after the passing of the single bench order, my lords. So, my lords,
assuming that there is a direction for closing the unit, they have to close their records and all books of accounts and everything.
Yes, madam.
So whatever is due, they will.
Milos, they have not
try
been
to
asked to do
recover.
that. Milos, may kindly take the order. They have been only asked to square off the derivatives and close the shops. They have not been asked to recover any such money.
And assuming it is not there,
Madam.
they will not do it.
Milos,
Are they stopped from doing it under any provision of law?
Milos, no, they're not stopped, Milos, but in my respectful submission, Milos,
You were listed
yes,
from 2014 onwards
yes,
without paying any charges.
no, Milos, I have paid annual listing fees.
Have you?
Prior to that,
Show
Milos,
me.
prior to that, after 14, I have not
13
paid.
you have paid.
Yes, Milos.
So you
14
are aware that you are required to pay an annual listing fee.
Milos, I have a reason for that also,
A
Milos.
reason is separate.
Yes, Milos.
You had problems, no trading, you could not pay the fee is a different thing.
No.
But if you are required to pay something, and if they have charged you, you cannot say that this will cause unjust enrichment.
But subject to correction, they have to follow the notifications and the operating procedures which have been initiated and brought in existence.
Yes. Show me what was the SOP for the year 2014.
For the year
2014, from which
that was the 2019 SOP, Malod.
How can 2019 SOP be there for 2014?
Let me kindly take the next the notification dated. It is there in the writ petition.
Yes. Now, will you please show where are the invoices? Where did you raise the bills?
My lord, the issue over here is not relating to the annual listing fee only.
It's not.
Listing obligation and disclosure requirements. The company, apart from making payment of the listing fees, is also required to make certain disclosures in terms of the listing obligations and disclosure requirement.
Disclosure, I'm coming later on. He has only placed
Disclosure also, Malad, I'll deal with it.
Yes,
there's only one regulation.
He has not yet submitted.
On that.
He has only submitted with regard to the annual listing
fees.
Show me that you've raised the invoices.
My lord, invoices, those have not been, if your lordship so commences, if it so commences to your lordship, I can file a supplementary affidavit.
Why, sir? You have already filed your opposition. When will the court give you
Because on the
this
last
time?
occasion, my lord, the affidavit was directed, my lord, to be filed on the basis of the fact of what is the due which is liable to be paid by the company. Yes, if my learned
Very
friend-
well. What is the due provided you raise proper bills? You cannot have a calculation in your record, not intimate to the petitioner.
That is there on the portal, which the petitioner, if listed, is under the bounden obligation to have a look at it and make the payments quarterly basis.
And you are not required to
Not required to raise. I'm not required to raise invoices, but subsequently, my lord, this regulation has come in as late as in 2020. By then, my lord, the petitioner have not been complying with any of the regulations. They have not provided the disclosure pertaining to the
disclosure. He is
the
not made
shareholding,
submission.
Who is running the company? Not a single particular has been coming forth
All right.
on behalf of the
You show me that you are not required to raise invoices.
Well, post 2020, I am required to.
Prior thereto, you
Well,
are not.
that is a point which has been brought up today, my lord. If your lordship allows me, I'll look up, my lord, the regulations which were in operation prior thereto, and my lord, I'll come back and make submissions according. Because, my lord, at this juncture, I wouldn't be in a position to say, my lord, that the invoices were required to be paid, to be served upon the petitioner. Now, my lord, the issue over here at that given point of time was the listing agreement provided that one will have to pay listing charges annually.
How? How is one? Is it a fixed annual
It
listing
used to
fee?
be a fixed rate when the petitioner had entered into the agreement with the stock exchange. But
From
subsequently, my lord,
2014 onwards, what was
it was
the
much
practice?
prior, my lord. They have been listed since 1995 odd.
No, issue is from 2014.
Issue is from 2014.
What was the SOP at that point of time? The requirements,
I'll
the
be required to look
formalities?
into it, my lord, because these are old documents. The regulations are past regulations, my lord. That has to be looked into. Allows me.
You take instruction.
Milord,
That
SOP is there.
please show me.
Milord, the 2019 SOP is there. Milord,
No,
but,
no, from
but I have to ascertain
2014
whether there was any one prior to that or any one SOP prior to 2019 government.
till 2013 you paid.
Yes, Milord.
Is it your case that till 2013 invoices were raised regularly?
No, Milord, because invoices are supposed to be raised for non-payment of ALF, Milord. I have to pay ALF, Milord. According, Milord, prior to 2013, Milord, I'll take sufficient instructions and come back, Milord, as to the procedure, Milord. But prior to 2020, 2019, Milord, 2014, I have paid, Milord. That is not in dispute.
It starts off from 2014.
2014, I was suspended, Milord.
Yes.
For non-compliance of Regulation 33, which they are saying. Now, Milord, that regulation also I'll show to your lordships, Milord, that enables them to do two things. Number one, suspend me or keep charging of fines. They have suspended me, so they cannot charge fines, Milord. And they have not charged fines. So suspension is in effect, Milord. So,
And you are happy with the suspension?
Milord, subject to correction, Milord, I am fighting a legal battle with my own brother. with regard to this company before NCLT, and I have disclosed all of that, my lords. And those proceedings are in advanced stage also before this High Court, my lords, because we are in a tussle trying to execute an award also to divide the properties. Because there's a lot of dispute between the family members and the company also going on. That is the reason we are not able to restart the company. But now, my lords, the endeavor is to somehow get it back on its feet if possible. My lords, and my lords, the intention is to show to your lordships that, my lords, this final SOP supersedes the previous SOPs. Now, my lords,
supersedes on and from a particular date.
No, my lords, it doesn't indicate subject to. It says, my lords, all actions will be gone.
It cannot be.
My lords, subject.
Sir, that is a wrong understanding.
Very well, my lords. I'll try to look at the other notifications and come to it.
Please come. To allow the parties to come ready with proper instruction in the matter. Release the same for further consideration on 10th of November 2025.
This 10th of November?
Yes. You fight out all your legal battles elsewhere.
Great.
Just comment my instance, my lord, I have mentioned.
And for the applicant, one can. And for the private respondent. My lord, kindly see the last order.
This matter, order was passed on 7th.
Yes, that is my grievance.
There was a direction to intimate the other side.
My lord.
Your learned friend has submitted that no intimation was served upon him. The court was not made aware, and the court passed order. His appearance is not recorded, and he is answerable to his client.
My lord.
What will be your explanation?
That day, my lord informed me to give notice to the corporation. I give the notice to the corporation. My learned friend appeared on that occasion.
Is it your case that you make parties to the others? You implead several parties.
No. My case is violation of the court's order.
The state is not a party in the
Yes, my lord. Respondent number 4. This is my engagement. My learned friend served upon the office of the learned government pleader on 24th of March. My lord, I understand the order dated 6th of March that has been passed for service of notice. There is no, my lord, likelihood that the respondent will appear prior to service of this notice. But my lord, this matter again
Respondent number 4.
Yes.
You have implemented the officer in charge of the Newmarket
by
police
name.
station as party, and you will not give notice?
My lord, on 10th of July, it was item number 420. My learned friend mentioned, and last day also.
Yes,
my lord.
I understand.
My lord.
Will you not give notice?
No, my instruction is we have not served notice.
Why? This is the query. You take an order behind the back of your learned friend only by mentioning the matter and getting it heard. The fact that the court is trying to accommodate the advocates does not mean the advocate is going to take advantage and not serve notice upon the respondents and obtain orders. This is never the intention of the court. Please make it clear.
We move in the morning and direction to serve notice to the corporation. That is the mistake on our part.
How can it be that only the corporation is to be served when there are other parties also?
Ekdom.
It can never be. When you mention the matter, the file is not in front of the court. The court believes the learned advocate.
Yes.
And then you obtain an order?
Well, that is.
Yes, sir. What is your submission?
My lord, in fact, no notice was served even prior to mentioning. My lord, I was lucky to be here, which is why I came to learn, and I was, my lord, before your lordship that day. I am for the private respondent.
And my lord, learned advocate appeared on the last occasion by the private respondent and the state all. Well, kindly see the order.
Which order?
The last order, that is 7th August.
Where is the state respondent represented?
No, not certainly not. But regarding private respondent.
Did you serve notice?
Yes.
Show the notice.
They have appeared, Mala. Kindly see respondent number 5.
He says he was luckily present in court, saw the matter taking up, he appeared. Did you serve notice?
No.
Then
I serve only the corporation lawyer.
Then next time onwards, I'll stop this practice.
No,
it is the advocates who will fall in trouble.
My lord,
the court is not concerned. The court is here every
my
day.
lord, direction to serve corporation. Also, I have served corporation. My learned friend appeared.
My lord, it's my duty to invite your
my lord,
lordship.
I will serve all the respondents. That is not the problem.
Please come. The matter has appeared in the list on mentioning by the learned advocate representing the contemptor number 4. The officer in charge, Newmarket Police Station. Stop. It has been submitted that order was passed on 7th August 2025 without giving notice to the learned advocate representing the aforesaid respondent.
And also on my lord 10th of July. 10th of July also. It was item number 420, my learned friend mentioned, taken out of turn without notice. 10th of July also, my lord.
This has come at the instance of the corporation. Possibly he had submitted that the order has been complied with, and that is the reason it has come. 10th July, I am not touching.
My lord.
Malad 10th July, Malad, I was served with the notice, but on the last occasion, Malad, I was also not served with the notice.
7th August, you were not served with notice?
No, Malad, I received a phone call.
Yes, for at least some information.
Malad.
Then you do not say phone call is also a mode of servicing notice.
Well, another set of lawyer appeared on 7th August. That is the Sijan Nayak and Rituparna Maitra. For the contempt, the Sijan Nayak appeared for corporation.
It's appearing for the contemptor.
I'm appearing.
And then on the last occasion, somebody else appeared. What is it?
Because Malad, on the last occasion, I received a phone call. That is what on the 11th hour, Malad, I received it. Then Malad, I communicated my learned senior brothers to Malad at least be here. So what is happening here to see? That is what.
So you were aware that the matter was taken up.
Inform him.
Acha, ki bolam?
You submitted that order as passed on 7th August without giving notice to the
Yes. Admittedly, no notice or information was given to the learned advocate representing the aforesaid respondent. Stuff next. In view of the above, the order dated 7th August 2025 stands recalled. Stop. Let the matter appear in the list on 14th August 2025.
14th, I have, my lord, kindly. My lord,
14th, you have got difficulty. 21st of
my lord,
August.
great.
Has been complied with, your lordship can drop the contempt proceeding.
I will drop it on the next day.
My lord, great.
21st of August.
21st. Great.
My lord, the order of unauthorized construction be that portion be, my lord, the corporation was party in the all occasion, my lord.
Yes, next one.
Item number 2.
My lord, great.
It will be hard on 21st.
Yes.
My
Yes. Item number 2. None for the petitioner. Stop. The matter was mentioned. By the learned advocate representing the petitioner, praying for withdrawal of the writ petition, as the petitioner was not desirous of prosecuting the writ petition. As none appears, the writ petition stands dismissed for default. For the petitioner লিখে দেবেন. Dismissed for default. কেন?
Lordship, I appear for the petition. Lordship, this is a matter where we have challenged the termination of a tender. I'll show your Lordship only 3 documents. Just narrate the facts in brief, my lords. Tender was floated sometimes in February 2024. Thereafter, Lordship, monsoon season comes in and the road which we had constructed got damaged. We were told to rectify. We rectified once. Again, there were floods. It got damaged. Then there was series of correspondences between me and the tendering authority. Thereafter, my lords, in January 2025, that is after the first extension that was granted to me, during that pendency, my lords, a meeting was held before the engineer-in-chief and ex-officio secretary of the department in Nobanno, wherein all the respondents, including the executive engineer, the superintendent engineer, the tendering authorities attended in my presence. And it was categorically held in that minutes of the meeting, my lords, that the damage has been caused because of the rains. There was no default on our part. It was decided that a closure proceedings has already been started and a concurrence would be given and a no defect liability period certificate would be granted to me. Only thing remaining was they would do a last measurement based on which my final amounts would come out. This is in January, my lords. Pursuant to this, in April, our inspection was also done in my presence. Suddenly, in the month of June, my lords, I receive a communication saying that it has been suo motu extended after 3 months of its last expiry. It has been suo motu extended, go rectify the work. I give back a reply saying that how can this happen, because unilateral extension cannot happen, specifically in view of the minutes that has happened. They, in complete ignorance of this, my lords, and the minutes that was there, complete ignorance of this, my lords, they go ahead, give me a show cause. They give me a show cause and finally they issue a notice of termination.
Show me, please.
My lords will just kindly take up page 67 once. I'm showing, my lords, the minutes. This forms the crux of my lordship. This is minutes of meeting held on 27th January 2025 at 12 p.m. Lordship will kindly take note. Office of the Engineer-in-Chief and ex-officio Secretary, Public Works Department at Noban.
Yes.
Lordship, this is the highest office of the department. Lordship may just kindly skip to the next page, my lords. It is I'm skipping the estimated amount and the tender amount. My lords, kindly takes the next page. Lordship, in the middle, there is present condition. If Lordship has got it. The road has been severely damaged by flooding and the subsequent passage of large number of heavily loaded commercial vehicles over the damaged road. Approximately 1.5 kilometers of the road remains in good condition, while remaining portion is a dilapidated state. Public agitation is escalating daily. Lordship, view of the agency Urja Infra, the petitioner before Lordship, has been directed to rectify the works. However, they have stated that it would be very difficult for them to undertake such repair. Now, Lordship just kindly sees the decision. An e-file has been initiated for obtaining necessary concurrence. Lords will take note, it's not approval, concurrence for foreclose of the existing contract with no defect liability period under clause 3B of the tender agreement so-and-so, wide e-file number so-and-so. According to the report from the working wing, the work completed so far has been executed in accordance with the work specifications and measurements have been recorded in the measurement book. Payments have also been made except for the full rate of dense bituminous DBM and payment for a certain quantity of earthwork carried out, which are pending due to post-level measurement, subsequent calculations. However, the Road and Building Research Institute will cross-check the work and submit a report at the earliest. Next page, my lords. the concerned executive engineer has been directed to make necessary preparation for immediate repair of the road by inviting a fresh notice inviting tender under the non-plan head, subsequent to the decision to close the present tender. Lordship, all our contractual rights crystallized. And Lordship just kindly sees the next page as to who all attended the minutes, my lords. To kindly sees the next page. Lordship, number four is the superintending engineer, and serial number 5 is the executive engineer. Lordship, so they have all attended. This minutes was done in their presence. My first thing is, my lords, that our rights under the contract crystallized as per this minutes. Lordship, pursuant to the minutes, Lordship will just kindly take up the next page, page 71. This is a report which was given by the chief. It's an internal communication of the secretary, my lords. Quality checking and inspection report. This was forwarded. And I say it is in pursuance of that minutes, my lords, read in the minutes. The building research had to do that report, my lords. The report is in page 73. It's a little technical. I'll not trouble my lords with that. Lordship kindly takes up page 75.
Yes.
Lordship, in page 75, it is in 2nd of June 2025. Lordship kindly sees. This is a suo motu extension that they are granting. With reference to the above, I wish to inform you that as per work order, the scheduled date of commencement of the subject project was on 29th February. Completion time was 9 months. You are bound to complete by 28th November. You have measurably, should be miserably failed to fulfill your contractual obligation. You stopped execution of work after floods in August 2024. During monsoon 2024 and after monsoon 2024, your executed works have been damaged severely, for which rainwater is not the main reason. From different experiments and reports, it is established that your workmanship is also liable. This is in complete contradiction of the minutes, my lords. There is no subgrade failure, but damages occurred over the executed work. No flood water overtopped the road as report received from the Irrigation and Waterways Department. In spite of this, your half-done work has been damaged. You took shelter of force majeure clause. Lordship, allegations completely in contradiction to the minutes. Lordship may kindly come to the next page. Second paragraph, my lords, I wish to bring to your attention once again that you were required by this office's memo dated 9th December 24. This is prior to the meeting, my lords, to rectify the damages that occurred in the work executed by you, to ensure the road remains traffic worthy, and to complete the remaining works. Suo motu extension of time had also been granted up to 28th February. A reminder in this regard has also been issued by memo number so-and-so dated 16th December 2024. The department's good gestures were ignored by you, and in response, you have sent a conditional proposal for execution only paver block work with a defect liability period. Lordship will just kindly see, I'm just taking Lordship to the last line in the middle of this paragraph, Lordship, the condition of the road is deteriorating day by day. Public agitation is growing due to a dilapidated condition of the road, and fatal accidents may occur at any time due to its poor condition. In those circumstances, as per direction of higher authorities, a suo motu time extension up to 6 September 2025 is hereby granted. Lordship, this is their sudden unilateral extension. I give a reply, my lords, it is in page 77. In the reply, I specifically point out that after the minutes of meeting, any action in contradiction of those decisions in the minutes would be illegal and void. If your lordship so pleases, I may place my reply, my lords. It's in page 77. I am not reading out the entire reply. Lordship kindly takes up page 81. I get a show cause because my reply is, as I stated, pointed out, my lords. Lordship, page 81 is my show cause on 13th of June.
Yes.
Lordship, they say that, Lordship will just, it's a small one, I'll just read it out, my lords. With reference to the above, it is regrettable to note that your reply is not at all convincing, whereas it appears to the undersigned that the work entrusted to you has not been proportionately executed in relation to the time elapsed. 4 reminders were issued to commence the work at site.
Do you have you annexed the contract?
Lordship,
you were exactly supposed to do?
Lordship, the contract, my lords, I have annexed my RTI, Lordship. After we enter into the contract, it's an agreement which I have to submit and they have to provide me a copy of it. That was not provided. So the RTI I have enclosed, it's in page 90, my lords. I have sought for a copy of that contract, which has not come to me. I am carrying one of the draft other contracts of West Bengal, form number 2911, which is generally executed. Now that doesn't have a arbitration clause anymore, my lords. That's something I have checked, but I have not yet been handed over the contract that I have
Arbitration
entered.
clause has been done away with.
Lordship's aware of this.
Yes.
So my contract, Lordship kindly sees page 90. It is my application under the RTI, which I have made to the public information officer, and point number 3, that is in page 91, I've sought for a certified copy of the contract agreement executed between the department and ourselves in respect of the above referred work.
Yes.
So, Lordship, I have not been made over that contract.
Right.
So I could not have annexed it, my lords. My lords, what I say is after this, Lordship will kindly see the second show cause, which is in page 101. And finally, my lords, I'll show 3 more documents. Page 110. It is on 28th July 2025. Lordship will just kindly bear with me. 110, 28th July 2025. It's a termination. Lordship, this is my termination. Lordship kindly sees.
Clause 3 of the aforesaid agreement. This
Lordship,
agreement copy is not with you.
Not with us, my lords. That's what I have sought for.
Right.
Lordship, this is the termination. Lordship, very peculiar situation. Lordship kindly takes up the next page also. 112. Lordship, let me just read out 111, my lords. 111, I'm reading out the second paragraph, my lords. Therefore, under powers delegated to me under clause 3(9) of 2911, I, Jyoti Prakash Dhar, Executive Engineer, HON'BLE Construction Division, PWD, the engineer in charge for the aforesaid work under the aforesaid contract agreement for and behalf of the Governor of West Bengal, hereby rescind the contract as aforesaid, and upon which determination or your earnest money deposit and security deposit already recovered for executed work stands forfeited to the government and shall be absolutely at the disposal of the government. Lordship, this is the usual termination. Lordship kindly takes up the next page. 112. This is a letter issued on the same date, 28th July, by the office of the superintending engineer. That is the superior of the previous issuer. Lordship kindly sees the the tenor of the letter. Lordship, I'm just reading out the second paragraph, first page, my lords. You are requested to read memo number so-and-so dated 24th June 2025, which clearly state that you executed only around 65% of the work. So your claim of 90% of the work you have done is totally wrong and not acceptable. You are once again requested to go through the correspondences made by the engineer in charge of the work, that is the concerned executive engineer, HON'BLE Construction Division, PWD, where he several times requested you to rectify your defective works and resume the work to complete the balance work for the public interest. But unfortunately, you ignored public suffering and all requests from the end of the department and not resumed the work. Moreover, the Irrigation and Waterways Department, Government of Bengal, never admit that flood water overtopped, nor there was any stagnation of flood water over this particular road. Your individual claim of stagnation of flood water over this road without any authentic document is not acceptable to the department. Lordship kindly goes to the next page, 113, and Lordship sees what he has directed me to do. Hence, your claim of damages of executed incomplete work for flood water only is also not acceptable to the department. Considering the public sufferings and to avoid any accident, you were several times requested from the department to rectify the defects and complete the work. So your non-response regarding rectification of damages and execution of the balance work compelled the department to take penal action against you as per clause 2 of the said contract agreement. If you were resumed the work, took up rectification and complete the work in all respect up to satisfaction of the department, then withdrawal of the penalty which has been imposed under clause 2 of the contract agreement may be considered. Lordship, this has been issued on the same day that I'm given a termination notice by a superior officer. And Lordship, on the same day, another notice has been issued, my lord, which is in page 114. That is by the superintendent engineer to the executive engineer. That is in page 114. Lordship, it's a communication. Lordship kindly sees In inviting to the above subject and references, the undersigned would like to inform him that as per clause 3 of the said agreement bearing tender number so and so, as engineer in charge of the project, he may take necessary action on behalf of the governor of the state of West Bengal, as he has power to adopt any of the courses of the clause 3 as he may deem best suited to the interest of the government. Lordship, on the same day, the superior officer gives a power to the executive engineer, gives me a letter saying that if you choose to resume work, we will consider the penalty. And on the very same day, I receive a termination notice. And all of this in complete disregard and suppression of the minutes, my lords, which I placed before my lords. And lordship, they have said that as per the termination notice, my security deposit, earnest money, all gets forfeited and is at their discretion. Lordship, all I'm saying today is that the rights of the parties crystallized as per the minutes, which was in the presence and which was held at the office of the highest official. Lordship, we were assured of a no defect liability certificate, and they were directed, the concerned executive engineer was directed to issue a fresh NIT. At their own whims and fancies, they give me a unilateral extension and only give so that such a suspension and termination can be done, my lords. This is the arbitrariness that I wanted to bring forth before my lords. Today, I'm asking that let them not deal with my security, my earnest money and my security deposit that goes around to around 1.9 crores, my lords. Because the RA bills that they have deducted, the security deposit is around 1.8 crores. And there's a 10 lakh rupees EMD, my lords. And they need to act as per the minutes, my lords. They cannot, in suppression of it, act contrary to the same. This, my seniors here, my lords, if there's anything else.
Just one aspect, he's placed the entire case. Your Lordship has very patiently looked through all the documents. One thing Your Lordship will just make a note of, the show cause notice is being issued by someone else. In that show cause notice, he writes, I will arrive at a satisfaction before I give you any, considering your reply. He thereafter acts completely at the dictates of the authority of senior superintending engineer, which is at page 114. Because if Your Lordship looks at page 114, and I wanted Mr. Mukherjee to just harp on this one. The show cause notice language I'll just place once. This is at 101. The executive engineer writes, please note that in case no cause is shown, I'm sorry, that's 102.
Yes, continue.
In case no cause is shown by you within the stipulated period, or the cause shown is not to my satisfaction, I shall recommend to the superintending engineer to such action as against you contemplated under clause 3. So his satisfaction, his show cause, my reply, he recommends the action. Your Lordship will just once now have a look at, this is 28 July is my termination. Kindly have a look at page 114 once.
Yes.
28 July. Now the senior superintending engineer writing to the executive engineer, show cause reply so and so. Your Lordship will not find that in the reference there is any iota of indication of the executive engineer having arrived at any finding regarding my complicity or inaction. That is what the show cause says. The reference bears nothing. It's directly 5 is show cause, 6 is the reply, and then the senior superintending engineer, he directs, in inviting to the above subject and reference, the undersigned would like to inform him that as per clause C, 3 of so and so, as engineer in charge of the project, he may take necessary action on behalf of the governor. So this is completely at the dictates. So first the show cause is by the executive. He says, you reply to me, I will consider it. If I don't find it satisfactory, I'll recommend the punishment. In the subject reference to the document at page 114, which is the same day as my termination, there is nothing that is being forwarded by this executive engineer to the superintending engineer. It's straight show cause 6, and straight away the senior superintending engineer saying, go ahead and impose condition. So there is no second, my lord. Your Lordship has seen, I'm not going to trouble Your Lordship with this, but the termination notice Your Lordship has been shown, my lord, at page 110.
Yes.
This again, in the reference documents, Your Lordship will not find any mention of the minutes of the meeting which was held on 27th of January. Although all these officers were present, they were signatories to that document. And the reason is, well, kindly have a look at the reason once. At page 110, last paragraph. And whereas you have suspended the execution of the aforesaid work, as per the opinion of the undersigned, the engineer in charge, you will be unable to secure completion of the work by the extended period, date of completion, show cause, so and so. So all the other allegations of the workmanship, that is not a ground on which the contract purportedly seems to have been terminated. The solitary ground on which it has been terminated is my apparent failure to complete the work. This is totally divorced their minutes of 27th of January 2025. And one more thing, Lord, Your Lordship will again see, he writes, show cause notice, not reply to satisfaction of engineer. This is again being issued by the executive engineer on the same day that he receives it from the superintendent.
All right.
These are my respectful submissions, my lord. I am not troubling Your Lordship with the latest that Shobha judgment. We've cited that before, Your Lordship. Then termination also, Your Lordship can interfere if it's illegal.
My lord, today I'm not having the written instruction, but whatever the oral instructions I have, well, the three things that I have noted, that the tender work order was accepted on 28 February 2024. Within 9 months was supposed to complete the work. 9 months, the schedule of completion date was 29th November 2024. Thereafter extended, and now the extension is till 6th September 2025.
The petitioner is not willing to complete the work.
Now, well, since August 2024, without assigning any reason, the construction till date is stopped.
No, he is not willing. He has disclosed, and it is recorded in the minutes of the meeting, which is there at page 67.
But the work that is 68, the agency categorically has directed to rectify the work, whatever has been done by him.
Page 68.
Well, kindly have a look. That
Page 68?
Page 68.
Yes.
It is that minutes of the meeting that has been pointed out.
Yes.
Under the present condition, Lord, after that, view of the agency has...
There was no defect liability period in the contract, in the agreement.
May I just indicate three things, my lord. In the NEET itself, it has been stated that it is the sole responsibility of the contractor at clause 32, C32. It will be the sole responsibility of the contractor to protect the incomplete work from all environmental issues.
Where is it?
That has not been annexed. The NEET is not in the over here.
He says that the copy of the agreement was not served. He doesn't even know what is there in the agreement. But what can be understood from page 68, the decision, it appears that he is not inclined to continue with the work.
Yes, but till that period, my lord, a substantial amount of payment has been given, and my lord, 65%.
How? Now I'm going to hold your officers guilty for this. The road has admittedly not been completed properly. Payments of crores has gone down the drain. Again in the monsoon, a top layer will be put over there and again washed away. Is this the way your authority functions? I am not with the contractor. I make my mind very clear. I am not with the contractor. He is definitely at fault. But what are your officers doing? I can see that they are absolutely in hand and gloves with these people. Public money going down the drains, and every day there is agitation. In each and every page there is mention that there is local agitation and fatal accidents will take place.
Well, let me come up with an affidavit, my lord. This needs an affidavit because this need has to be annexed, my lord. because the specific paragraphs, specific instructions are there.
Can you please take strict steps against these type of contractors who at the time of bidding, they put in all types of documents and everything and they do not complete the work and then go away. And these legal complications land up in the writ court.
I'll take instruction that what steps has been taken. That has to be in the form of an affidavit. It should come up before your lordship.
Please come.
Because in spite of, they have already stopped. That
May I
is
just pray for one thing, my lord. Let them not take any coercive steps while your lordship is considering this.
I have made my mind clear. I am not with the contractor. His conduct is just, the better we ignore it, the good for us. You walk down, you travel down this road, and you know what's going to happen. The matter relates to a contract which was executed by and between the petitioner and the state authority. Stop. The contract, according to the authority, the petitioner was unable to finish the work. Stop. The authority has taken steps against the contractor. Stop. The contractor is aggrieved by the same. Stop. The copy of the contract is not annexed to the writ petition, allegedly on the ground that the same was never handed over to the contractor. Stop. Next. The contract appears to have been terminated by the authority. Stop. The authority is also proposing to take coercive action against the petitioner. Stop. Next. The learned advocate representing the state respondents seeks time to take instruction in the matter. Stop. Let a report be filed before this court disclosing all facts and figures. Stop. A copy of the agreement will also be annexed with the affidavit. Stop. The defense redressal mechanism not defense, is the dispute redressal mechanism under the contract shall also be disclosed. Stop. How soon can you come back? Fortnight's time will be all right. Possibly.
it has to be.
Today is August 26th. Release the matter on
Put in the
26th.
form of an affidavit.
Somebody will sign it. If you cannot prepare the affidavit, also make a copy and serve it upon the petitioner in advance, so that the next day the petitioner gets to know whatever is there in the report or affidavit, whatever. List on 26th.
Look, in the meantime, let them not take any.
Let's see what will happen.
Look, they'll take steps. They'll
And what is going to happen to any fatality which takes place during this time?
27 January, they had themselves said that nothing has to be done. I'm not at fault here. Specific finding that I'm not at fault.
You do not finish the work, leave it unfinished, and now you say you are not at fault.
Till that day, my work was over. Whatever I had to
your work was not over. The decision is very clear.
Yes, that was because of the flood.
No floods. The report says I'm going to dismiss the writ petition, and I was thinking of dismissing, but then I want to take action against these officers. That is exactly the reason why the writ petition has been kept pending. Otherwise, I would have dismissed it here and now, because there are disputed questions of fact. You say you have finished the work. Flood water damaged the top layer. According to the reports of the authority, no flood water was there. Why will the court accept the writ petition?
If there are disputed questions of fact, I will not invite you.
There are disputed
Except that
questions.
page 68 really crystallizes the issue here.
Nothing.
But I understand that. Till your lordship dismisses it, at least let them not take any coercive steps.
Let's see. The court is there. Court will take care of it. Yes, call the next matter. Yes.
My application, Lord.
Who is the respondent?
Your lordship recall, this was where they were using my drawing, although they had mentioned as a proprietary concern. We had served then, they had not appeared. Your lordship's desire was that we serve again. Now again we've served by hand.
Northeast Frontier Railway will not appear.
We have served by hand.
We've served by hand, not accident. We've served by hand.
Anybody from the central government panel?
এটা কি?
The
এটা কি?
railways.
Data by courier Delhi Patnaji, and by hand also we have served courier.
This is the other one, Milord, where we have attempted service by courier and that has been served by hand.
And Ministry of Railways, Koilaghat refused to accept. Aage din file korechi.
Some places they refuse to accept it.
1 minute. Do you appear for the central government? The NF Railway?
It has come under the Ministry of Law and Justice only.
Has the notice been served upon 11th Strand Road?
They refuse to accept it.
We have filed that.
We filed the affidavit of service on the last occasion, they refused to accept it.
11th Strand Road do not accept.
Railways matter.
Railways matter, they don't accept.
Pilot direct pilot, I'll take instruction from the.
You can come back with instruction with regard to the Northeast Frontier Railway.
I can serve him a copy.
I'll serve him a copy right now, Milord.
1 minute. First, let me ensure whether you'll appear or not.
Let me take instruction. Why they have refused, I do not know.
Because this is the submission I have received earlier also. If it is NF Railway, these authorities do not accept.
My lord, kindly direct, my lord. I'll take instruction if I come.
Come back at 1:15. You take instruction whether you can accept the brief on behalf of NF Railway. If yes, then direction will be given to serve a copy upon you. All right. Come at 1:15, please.
I appear for the respond number PN4, Milord.
Yes.
And for the state. There is a usual tendency to ensure.
And for the petitioner, my lord,
Yes.
led by my senior Mr. Sudipto Dashgupta, my lord, is presently, my lord, on legs, my lord, before an ongoing matter in courtroom number 17, my lord.
You can continue, at least start.
My lord, I humbly pray for an accommodation, my lord.
For the day?
Anytime subject to convenience of this honorable court, my lord.
Accommodation for the day?
My lord. Not today, my lord. Not today, my lord.
Not today?
Not today, my lord.
The report will submit.
Next week you will submit report? Next
My lord,
week?
kindly, my lord, there is some urgency, my lord. This is the leave matter which had been mentioned, my lord.
I'm passing it over. Call him.
My lord.
Yes.
Number 30.
My lord, if I am stuck, my lord will kindly accommodate. My lord, if I am stuck, my lord kindly.
There. 1 minute. They've come. Yes.
দৌড়ে এসছো না না আমি জল উঠেছে একটু আসতো
Yes.
My lord, I am for the
Yes.
Here, my lord, petitioners were employees of the government. Under a scheme, they were allotted flats, my lord. It's we are been allotted with the deed, my lord. Deed shows the flat. We are the owners of the flat, along with the proportionate common areas and facilities, my lord. Now, my lord, there were for our group there was no car parking. For higher income group, there was car parking of around 280%. Now the government decided that we will increase that to 480. Now what they are doing, my lord, in our common areas, they are constructing the garages, which in fact, my lord, will block our walking space and ingress. This is, we are saying it cannot be done since we are the owners, proportionate owners of the common areas and facilities, and without taking our consent, it cannot be done. And also, my lord, your lordship knows, this is under the Apartment Ownership Act. There is a specific bar without the consent of.
Did you raise all these issues before?
Nothing, nothing, my lord. There is an
competent
arbitration
authority?
clause, my lord. He
My
did
lord,
not approach.
arbitration clause, my lord, I tell your lordship, what is
the classic example? If you do not get it, ensure that no one gets it.
No, I am not entitled to it. I am not wanting that I will get it. GIC.
I'll show the picture, my lord. May I hand up?
Lord, kindly see, I have the entire, the enlarged one.
No. You show me that you have raised this issue before the competent authorities. Because the authority is to decide this.
There is an arbitration clause, my lord. Will find it.
No arbitration.
I'll show. I'll
Get
kindly
your deed.
page.
My lord, deed is at
Page 71, I can see one saying.
My lord, kindly come to page 81. That is the common area.
1 minute.
page 47.
Page 47.
My lord, the common areas, your lordship will find that page 58, the schedule.
All right, 58.
My lord, 58 details of common areas.
Details of the common areas. Which portion has been infringed now?
It is the concrete road and, my lord, the common 7, 8 and 1, my lord. 1 and 8. Community hall, the area, and the concrete road, 1.
Concrete road is 1, compound road.
Yes.
Description such and such, and community hall.
Yes.
What are they doing in the hall?
My lord, the hall, community hall, my lord, they are planning for an indoor as well as an outdoor facility, and the road leading to the community hall, they are planning to construct a garage, and the concrete road, which is the entire building surrounded by this concrete road.
They are making construction over there. All right.
It is clear from the plan, my lord. It would be also be clear from the.
All right. Yes, respondents.
Okay, kindly come to page 25. This is part of the general terms and conditions.
General terms and conditions of?
By which, my lord, every flat owner is abide by.
All right.
Page 25.
25.
My lord, will kindly see clause 10, right of amending general terms and condition. In case of difficulty to implement this general term, and housing department shall have right to issue appropriate directions.
So this has got 10 has got nothing to do with this.
I'll demonstrate.
Page 25. Kindly come to clause 12. What my learned friend is talking about.
I'll show what
One
is
minute.
my lord.
Arbitration, you say, that is page 25. All dispute between the parties shall be referred to arbitration appointed by the housing department. No, but then.
Right. No, my lord will kindly
is executed. My lord, housing department.
Yes.
Nobody.
The deed that is executed, my lord will kindly come to page 71. It starts.
Akanksha housing scheme. Now this scheme has it has matured. The flats have been given. What remains over?
No, what is impugned? What is impugned before your lordship? My lord, what is impugned before your lordship is letter dated 6th of December 2024, which is at page 100.
All right. Yes.
This is impugned.
My
lord,
if your lordship kindly see the third bullet.
My lord, this my lord will kindly see in terms of third bullet point, my lord, my learned friend is correct. My lord, kindly take note of the date, 6th December 2024. In terms of UDMA, department's notification such and such, car parking spaces in the project has been modified to 480 numbers. Initially, it was 287 and odd. Your lordship knows in terms of the building rules, there has to be a minimum number of car parking spaces in accordance with the number of flats. But initially we planned that we will have the housing department had planned that there will be around 2080 odd parking spaces. What 280? And the NKDA, my lord, did not grant such plan. NKDA said the minimum parking number has to be more than 500.
who are you representing?
My lord, I am representing the association. My lord, whose member at large? Please,
My lord, one minute. Association means
the apartment.
The apartment owners association.
Why? They have decided today. If he says I am not answering respondent, that he cannot file this petition.
No, I am saying this is the housing department.
I thought you are representing the state.
My learned friend is representing the state.
No, I won't hear the association. The association, I will not hear. I'll hear the state because it's a state action which is impugned.
No. My lord, page 102, my lord will find whose action it is impugned. It is my action. If your lordship says you will not hear my lord, I have nothing to say, my lord.
1 minute, I'll hear the state first.
According to the general terms and condition, kindly see the clause 8.6, my lord. Putting the disposition, the housing department shall hand over the possession of the common area and facility to the elected board of managers, preferably within 3 months from the date of meeting stated herein above, for maintenance and management of the same, but ownership of the common area and facilities shall remain with all the flat owners jointly as per West Bengal Apartment Ownership Act.
That is my case.
1970 as amended such
That is my case.
So as per the regulations of the managing committee, they are decided and 872 flat already constructed. Already money, already by lot, already collected the money. In the meantime, my lord, petitioner filed this instant writ petition.
If the common area has already been handed over to the parties and this is to be enjoyed jointly by everybody, then how can somebody encroach upon the common area and make construction of garage over there?
That not arise the encroach of the common area.
No, but then
according to the general body meeting, it was decided by the all flat owners, including the petitioner. They are decided and they advised to the government to construct the extra car parking space.
It is the petitioner who was also a party to the meeting and everything, the decision making process. Is it your case?
Body meeting already elected elected committee is there.
My lord, kindly come to page 90.
Elected committee is there.
98 Government of West Bengal, Office of the Executive Engineer.
The president of the association, the
Right.
tender has been issued and everything. So they are planning to do that.
May I only indicate this,
Yes.
subject to my lord's, your lordship said your lordship will not allow me to make my submissions.
Later on, yes. Now, as state has made the submission, now what is your submission?
Drawing, my lord, this is a classic example. If you cannot get something, ensure
No,
that
he is not wanting it. He is not entitled to
my lord,
either.
he doesn't want. Why is the shoe pinching? I'll demonstrate. My lord, everyone.
No, the court is not concerned with
I will
somebody
kindly
else's shoe. Let the authority take a
I
decision.
have no problem if they
Kindly hear me.
beyond the common
Kindly
area.
hear me before that. Kindly hear me. Kindly take the plan of the car parking spaces. These are the car parking spaces to be constructed.
Which portion?
Entire the marked ones, the purple ones and the red ones.
All right.
Are
good.
the total 500 and odd 480 car parking spaces that have to be constructed.
All right.
Model, kindly come to his deed. The deed starts as at page 71. দাঁড়াও তোমার ওইটা ডিড না 71টা তাহলে কি বলো 71 is the final 71 my will kindly come to it starts my will kindly come to page 80. We are not constructing 80 my lord, your lordship will see the third schedule is the common areas and common facilities.
Yes.
My lord, this is different of the two, this my lord will kindly see details of common area, common facilities provided in respect of 576 number of dwelling units of different types of flat and Akanksha are given below. Details of common area. Please wait. Please hold your horses. Please hold your. I'll show. Please hold your horses.
Whose deed are you relying upon? Page
My lord, his
71?
petitioners.
Should petitioner number 2.
My lord.
Yes.
My lord will kindly see.
Yes.
Different types of flat, classic, premium, and elegant. So this is the my lord common areas for 3 categories and not the petitioners. I will kindly turn the page.
Yes.
Page 81. Look, this is the common area of the petitioners.
All right.
I will see the difference. Concrete road. I will kindly turn the previous page. This concrete road 5m wide. So the 5m wide concrete roads belong to the other group, not this group.
All right.
Lord, this common areas, my lord will kindly take note of my submission that we are not building any of the car parking spaces on these common areas.
Common area of the petitioner. You are not.
We are not building. Well, this is an attempt to stall everything. because your lordship says my lord will not hear where the shoe is pinching.
Yes.
It will be essential because then the court will be able to know. Today, people are randomly, these two categories, they do not have their car parking spaces. They are randomly parking their vehicles all over. As soon as I built the car parking spaces in terms of my plan of the NKDA, sanctioned by NKDA, they will not have their free spaces left. My lord, this car parking space was never, my lord, allotted to them. It was always, my lord, unlimited. This was never transferred. My lord, kindly see. Your lordship has seen the sale deed?
Yes, sale deed.
My lord will kindly appreciate the difference between page 80 and 81. There has to be some difference because 80, my lord, has a mention of a 5-meter concrete road. 81 does not. But this goes to show on some of the concrete roads, and my lord, I go to the extent of saying that I am not even building on any of the concrete roads. The petitioner's common...
Who will be the appropriate authority to look into the issue?
The housing department will... Housing department. But my lord will kindly not stall it. My lord will kindly... This, my lord, has... Again, my lord will kindly, I very humbly, because, my lord, this has sentiments of many of the middle class. Your lordship will... because you don't have a car parking space, appreciate that.
One car parking space.
Then do not ensure that others do not get.
In my area,
my lord, this has sentiments and, my lord, households of hundreds of, my lord, middle class family. My lord will kindly not stall it. That is my very humble prayer, my lord. Your lordship will set aside everything if your lordship finds...
My lord, the association. My lord, only thing, the association is not for the HIG only. They are also
You don't have a
us.
parking space,
so how
sir.
can they espousing the cause of only
my
the
lord,
HIG?
my lord will direct that in the common areas as mentioned in page 81, there should be no...
Kindly see the page number 23, clause 7.1.
GIC has no manner of
The petitioners were allotted flats by the housing department under the Akanksha housing scheme. The sale deed executed in favor of the petitioners contain the schedule clearly mentioning the common areas and facilities provided to them. The petitioners allege that the association is housing association is taking steps to construct car parking spaces by infringing the common areas. The aforesaid allegation, prayer has been made to direct the authority to restrict such construction over the common areas. The aforesaid allegation of the petitioners are denied by the learned advocate representing the Association of the Apartment Owners. It has been submitted that no construction is being made over the common areas enjoyed by the petitioners.
I'm grateful.
Learned advocate representing the state respondents submits that the common areas which are mentioned in the sale deed ought not to be encroached upon. Next. Upon hearing the parties, it appears that the issue has to be decided by the competent authority of the state. Next. In view of the above, the instant writ petition is disposed of by granting leave to the petitioners to file a composite comprehensive representation highlighting all facts along with documents in support of the allegation of raising construction over the common areas meant for the petitioners. Step. In the event such a representation is filed, comma, the same shall be considered and disposed of by the Additional Secretary, Housing Department, being the respondent number 2 herein. After conducting a spot inspection, upon giving prior notice to all the necessary parties, and thereafter giving an opportunity of hearing to all the parties by passing a reasoned order. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of filing the representation. Next. The steps taken by the association for construction of car parking spaces in the common areas shall abide by the decision to be taken by the respondent number 2 in this regard. Read petition stands.
In the alleged common area, my lord.
Only one thing, my lord.
Yes.
In the alleged common area.
In the alleged common
I'm
areas.
grateful, my lord.
Kindly direct me to file a representation within a specified date. 3 days, 4 days. No, no.
Any time you file it within
Why
8
I am
weeks.
saying this, my lord. Your lordship, my lord, from experience saying it will never be done within 8 weeks. Everything garage will be constructed. I want, my lord, when given me a day's time, I will file so that it can be in the meantime, till the matter is being disposed of.
These
no
apprehensions
construction,
have no basis, my lord.
Otherwise, my lord, it will never be done. The construction, I will come up to contempt. It will take.
Yes.
Strictly, my lord.
No, thing is, if it is not done within the time limit, you know the contempt proceeding. You
But
can.
in the meantime, everything will be constructed.
You come back, I'll see. Next.
I'm grateful for hearing me, my lord.
My lord, service.
Yes, service is taken on record.
Item number 13.
13. Yes.
Happy for the rest.
Just indicate this one. Lord, loan was taken using 2 different accounts. Lord, there is a central government scheme also which is there. The issue is whether the NPA could have been declared after not having adjusted the amount that they have received through that insurance scheme. But today, my lord, may I just file a supplementary
I'm
affidavit?
opposing the filing of the supplementary affidavit on.
May I just indicate why they're opposing
It
and
is-
why this is, I want to file this?
Again, I am equipped to deal with it also, but it does not speak of any subsequent fact.
1 minute. Your intention on the last occasion was to clear off the dues by settling.
Yes, my lord, I'll tell you lordship why. Because if 100 rupees is what they say is outstanding, because of which has become a non-performing asset, they have received 80 rupees from the central government, that scheme. That adjustment they don't give. So in my understanding, once you give that adjustment, what is remaining is 20 rupees. Out of that 20 rupees I had given. But they have now
Listen, if
rejected.
the bank is not agreeable to a one-time settlement, the court cannot
Correct,
force.
not at all.
And
Lord,
lordship
I
had
don't want to
taken
argue something which is not available.
while the writ
If
is
they,
being
this is
heard.
absolutely the bank's prerogative whether they accept it or not.
Yes.
I'm on a slightly different point. My lord, from documents I'll be able to show that when the loan was granted to me, it was to the notice and knowledge of the bank that I am an MSME unit. Your lordship is aware, now that is settled by the Supreme Court decision, that when it comes to an MSME unit and bank was aware when the loan was being granted, the MSME 2016 circular applies. The circular mandates that you have to identify the incipient stress, form a committee, and only after the committee is formed can you declare an account as a non-performing asset. These guidelines I want to bring on record by way of a supplementary affidavit and show two decisions, one of a single judge of this honorable court, division bench
But
of
then
this.
what are you driving at?
That the declaration of my account as a non-performing asset itself is without jurisdiction.
The submission made on the last occasion and today are diametrically
Yes,
opposite.
no, it's in aid of my challenge. The other day, my submission, they came and because we had made that submission for one-time settlement. While the matter was continuing, we were informed that the bank had rejected it. Then we went up and checked. The night before the matter was taken up, they had rejected it. So we've gone back now that that chapter is over.
Surfacey proceedings are being drawn up. Why don't you go before the tribunal and you can get all these things done?
Lordships have time and again.
Tribunal has already rejected.
Yes, yes.
the interim application.
Just on a point of law. Only on the aspect of jurisdiction, not based on the Supreme Court judgment, that if the 2016 guidelines, Lordship will kindly have a look at the guidelines once.
Lordship, this does not introduce any subsequent fact and only an afterthought.
It's just on a point of law, my lord. My learned friend will not unnecessarily get agitated. This is not on fact at all.
Because this
kindly have a look at, my lord, two documents from the supplementary affidavit. Lord, page 9.
Did you serve?
Yes, we've served. Page 9, kindly have a look at. This is the jurisdictional fact. And I'll rely on two decisions just to highlight, to buttress this. Page 9, kindly have a look at. This is my Udhyam registration certificate. Type of enterprise is small. Ghosh Tractors is the petitioner before your lordship. And the date, my lord, will kindly make a note of. It is 1st of April 2021. Please have a look at sanction letter. The sanction letter I'll just show, my lord, where they themselves call me an MSME unit. Then I'll come straight to the other part of. The lordship will kindly have a look at page 64.
Yes.
Just to highlight the date. At 64, dear sir, this is written to the petitioner. Advances to SME segment, left-hand column, left-hand, my lord.
Yes, yes.
So this is being granted on 29th March 2022. So the bank is aware when the loan is being granted that I am an SME unit. I come under the MSME Act.
When was the loan granted?
This is the loan document, no?
This page 64?
Yes.
29th of March 22?
Yes. This is 29th of March and the bank calls me an SME unit. There's nothing else that I need to trouble your lordship with. Advances to SME segment. Sanction of credit facility, name of the petition is there. Now kindly turns over to page 10. I will not trouble your lordship with the whole of the regulation. I'll straight away come to the judgment after this.
Yes.
This is a notification of 29th May 2015. It's my Ministry of Micro, Small and Medium Enterprises. My lord, page 12, your lordship will find application to the committee for a corrective action plan. Then there has to be a committee. My lord, please don't be troubled by the entire circular because judgment considers it. One more document, my lord, page 23. This is July 21st, 2016, page 23, sorry. This is
yes,
July 21st, 2016. So it's before the loan was granted. This is a master direction regarding lending to micro, small and medium enterprises sector. Now there is a host of things that has to be done when you give a loan. Because it's an MSME unit, you simpliciter can't attack it and make it an NPA. Well, to buttress the submission, lordship will allow me to rely on two decisions. Lord. First, of division bench judgment of our honorable court. Well, this is anything. Well, this is reported in 2014 SCC online Calcutta 20626. Eki, amake copy দেন? আমি পড়ে একবার ফেরত দেব please. Thank you. Third learned counsel for the respondent bank. The entire dispute is with regard to declaration of the respondent unit as unviable by the appellant bank. It is not in dispute. Credit facility was extended to the respondent unit by the appellant bank in terms of the scheme meant for medium, small and micro enterprises. Certain guidelines for rehabilitation of these units were also issued in order to promote the micro and small industrial units. When an account becomes a non-performing asset, irrespective of whether it is a loan facility or credit facility given either under the scheme meant for micro so and so or otherwise, the loan has to be recovered by the creditor bank. in order to promote micro and small scale entrepreneurs, certain guidelines are made in order to see that if such entrepreneur has some financial difficulty, a procedure has to be followed which guarantees rehabilitation of sick entrepreneur. Therefore, unless the borrower who borrows money under the scheme is declared as an unviable unit by the bank, they will not be able to proceed further. In other words, before proceeding, please mark this, before proceeding with the recovery of the amount under recourse to Surfacey Act, the guidelines meant for rehabilitation of sick MSMEs is required to be followed by the creditor bank. The question is, when Surfacey proceeding under 13.2 was initiated, whether the guidelines for rehabilitation was complied with the bank, creditor bank or not. Complaining non-compliance of guideline 7B of the scheme, respondent debtor approached civil court for a declaration that the unit ought not to have been declared as an unviable without approval of the next higher authority as contemplated in the above clause. So and so, then kindly have a look at with regard to Surfacey Act, that issue had also come up. Page 2, the section that's the paragraph that starts with regarding. Reading of this provision clearly indicate not only a study report has to be made regarding viability of the unit, which according to the appellant bank is done by Texpro India, but the clause contemplates approval of the next higher authority for micro and small units. It further requires an opportunity to be given to the unit to present the case before the next higher authority, where they could even convince the modalities for presenting the case to the next higher authority, which would be worked out by the bank in terms of their board-approved policies. Apparently, except study report regarding viability or unviability of the units under part of clause 7B are not complied with, according to the respondent plaintiff. Prior to proceeding under section 13.2, these formalities under the special scheme ought to have been complied with, which is the stand of the plaintiff respondent. In that view of the matter, we are of the opinion that regarding clause B of clause 7 of the scheme and section 34 has no application to the list raised before the learned single judge. In that view of the matter, we are of the opinion that learned judge has taken care of the interest of both the parties, wherein the appellant bank is at liberty to consider the appeal and dispose of. It is needless to say that clause 7B of the scheme is a mandate on the authority concerned, which is introduced only to see no arbitrariness exercised on the part of the officials of the bank. In the absence of a proper exercise or compliance of the procedure contemplated in terms of the guidelines for rehabilitation, the debtor unit may even be suffocated with the result of closing down the unit by an arbitrary order. Therefore, unless the procedure contemplated and the guidelines for rehabilitation is complied with in accordance with the guidelines, subsequent actions or consequences for such non-compliance may lead to a disaster. And therefore, this appeal is disposed of on the ground that this has to be complied with before you take recourse to 13.4 and under Surfacey Act at all. Not just to buttress this a little further. Well, this has now been settled in 2024, volume 10, Supreme Court cases 292. But 14, before that, if you Lordship gives it a cursory glance, these guidelines are framed under the Reserve Bank of India and therefore mandatory. The statutory provisions are basically highlighted. 14 onwards, Your Lordship will allow me to place two paragraphs. In view of the above, it is absolutely clear that the instructions for the framework for revival and rehabilitation of micro, small and medium enterprises, as notified by the central government by notification date 29 May 2015, in exercise of powers conferred under Section 9 of the MSME Act as reserved by the Reserve Bank of India dated 17 March 2016. Both are part of my supplementary. And the master direction so and so issued by the Reserve Bank of India and exercise of powers conferred under Section 21 and 35 capital A of the Banking Regulation Act, having statutory force, are binding on all scheduled commercial banks licensed to operate in India by the Reserve Bank of India, as stated in the said directions. It cannot be gainsaid that the Banking Regulation Act basically seeks to regulate banking business and mandates the statutory comprehensive and formal structure of banking regulation and supervision in India. This regards 15, my lord. 16 onwards, your lordship will kindly have a look at. As transpiring from the said instruction or directions, the entire exercise as contained in the framework for revival and rehabilitation of MSME is required to be carried out by the bank before the account of MSMEs turn into a non-performing asset. Lord, I am on a jurisdictional fact here. I am saying, by relying on this judgment, that my classification of the account as a non-performing asset is divorced this because you've not followed the mandatory guidelines at all. It goes on, Milord.
And according to you, the fact that your company is MSME was within the knowledge of the bank.
Yes, I've shown my Uddham registration precedes the grant. Bank records in that grant that it's been given to an MSME unit. Milord, if I may just place the other two paragraphs, Milord, your lordship would have seen it. So I am simpliciter attacking the jurisdiction, Milord, now narrowing it down to absolutely a basic point. If the substratum is wrong, then the entire superstructure will have to collapse. I am saying that these guidelines have now been held to be mandatory without identifying the recipient stress and having these two committees where I also have an opportunity of going and representing my case. You could not have classified the account as a non-performing asset at all. So I want to highlight this by bringing these two and these judgments by way of this. Milord, the immediate urgency is today they are coming to take possession under Section
They are
14.
already taking possession.
Now that I'm sure while your lordship is in CSN of it, the respondent bank won't attempt to overreach the court. My lord, paragraph 18, if I may just place of the judgment.
What does the unit do? Ghosh tractors. That means some tractor.
It's a sole proprietorship, no?
Manufacturing or
They had
what?
as far as my instruction is concerned, they had a the outlet where they used to sell tractors.
I trade in tractors.
Yes.
Yeah.
Well, then not formally placing it. 18 of the judgment makes it very, very clear that without actually identifying the incipient stress in the account, before the account turns into a non-performing asset. So unless this is there, and Supreme Court sets aside whatever has been done and holds that this is actually a mandatory guideline. Paragraph 18 is what I wanted to just hold.
Yes.
The side, apart from 16, 18 your lordship will see. Only precondition is, I'm grateful, that the bank must know that I am an MSME unit.
Lordship, before I place my submissions on the supplementary affidavit, Lordship will kindly look into the prayers made in the writ petition, whether by way of this supplementary affidavit, they can expand the scope of the writ petition, because all they prayed for before your Lordship was a stay that and quashing of the order of the learned district magistrate, which is already the Debts Recovery Tribunal has decided in favor of the bank. Now, secondly, with respect to the supplementary affidavit, two documents have been indicated, one being their Uddham registration certificate of 2021 and thereafter page 64. Lordship will kindly once again take page 64. Now, page 64, it does not say it is an MSME. It states it is advances to SME segment. That means it is a particular segment of the banking loans are given to the small medium enterprise segment. The segment is only referred to, nowhere indicating that this is an MSME in particular, and this is also an enhancement of the loan at that juncture. That is in there was a rescheduling of the limit. The existing limit was 135, that is 1.35 crore. It was the limit was thereafter rescheduled. This is there was an existing limit, it was rescheduled, and it is only an SME segment. It is just mentioned as a SME segment. Not
What does this mean?
Lordship, it is a segment addressed by the bank. The bank gives finance to small medium enterprise segment. That
How
is
do you
like a
know?
Housing, Lordship,
How do you know that the unit that has approached you for the loan falls
there are
under the
certain-
SME
there are
segment?
certain criterias. I will. There are certain criterias, like it is a housing loan, it is small medium enterprise loan.
That
There are
means
several
that means
features.
the
It is a
unit is
segment.
a small or medium enterprise
It can be a small or medium enterprise
without the registration.
Most respectfully, possibly yes, but I will not even harp on this. I will come directly to the latest judgment, because this this afterthought has been churned or introduced mostly by the Prones judgment. Many matters Lordship has also herein ordered, and this is exactly what Lordship had in previous orders. Lordship has passed orders. Now it is settled subsequently, yes, by the Honorable Supreme Court on 28th of July. This was what the unrest has been created by the Prones judgment.
Yes.
The obligation of the borrower has been now specified, and it has been said that supposedly if the bank has initiated proceedings, it is not only the obligation cast on the bank, it is in specific terms the obligation of the borrower, and that has to be read together. Lordship, I will just please from paragraph 6 onwards. This is the way this urges to read the notification and the terms of the framework, if accepted, would lead.
1 minute. Paragraph 6.
6 onwards, yes.
6. Which portion are you reading?
The last from the last paragraph 6.
Paragraph 6 is a big paragraph.
Yes. Lordship, I'm starting from the first itself.
Yes.
Yes. To clarify, just that it is the obligation both ways. If the notification is accepted, would lead to the conclusion that every lending bank or secured creditor under the Surfacey Act would be obliged to find out in every event of counting default likely to give rise to classification of relevant account as NPA, whether the borrower is an MSME to which the framework applies, whether his business has failed, or whether it is suffering from any disability to pay its debts, and upon receiving a response to apply the terms thereof, inter alia including the account in the special mention account for the claim for a corrective action plan to be considered by the Committee for Stressed MSMEs. This could not have been the intention behind introduction of the framework to aid the MSMEs which, for reasons personal to them, is unable to clear its debts and require revival and rehabilitation that the framework envisages. If indeed it is the only obligation of the lending bank secured to identify incipient stress in the account, subparagraphs 2 and 3 of paragraph 1 would be rendered redundant. An MSME, despite finding that its business is failing or that it is unable to pay its debts or accumulation of losses equals to half or more of its entire net worth and classification of its account as NPA is imminent, it would rest on its oars, believing that it has no responsibility and that its account will not be classified as NPA because it is the entire obligation of the lending bank or secured creditor to do what the framework requires. We would read and interpret the seemingly confusing terms of the framework harmoniously to ensure that a right under the MSME Act is not destroyed by Surfacey Act or vice versa. In our reading, the terms of the framework do not prohibit the lending bank secured creditor, assuming that it has no conscious knowledge that the defaulting borrower is an MSME, to classify the account of the defaulting MSME as NPA and to even issue the demand notice under 13(2) of the Surfacey Act without such identification of incipient stress in the account of the defaulting borrower, MSME. However, upon receipt of the demand notice, if such borrower in its response under the section 13(3)(a) of the Surfacey Act asserts that it is an MSME and claims the benefit of the framework citing reasons supported by an affidavit, the lending bank or secured creditor would then be mandatorily bound to look into such claim, keeping further action under the Surfacey Act in abeyance and should the claim be found to be worthy of acceptance within the framework to act in terms thereof for securing revival and rehabilitation of the defaulting borrower. Herein, Lordship, may I also place the paragraph 5, Lordship, which I should have placed possibly before this. The notification detailing the framework, more particularly paragraph 1 and its subparagraphs, have to be read together to make its terms effective and meaningful. Although in the sequence of framework, identification by banks or creditors comes first, it is immediately followed by identification by the enterprise. In terms of subparagraph 2, any MSME may choose to voluntarily initiate proceedings under the framework if it reasonably apprehends failure of its business or inability or likely inability to pay debts, and before the accumulated losses of the enterprise equals to half or more of its net worth. The obligation of the MSME does not end there. For initiation of proceedings under the framework, the application has to be verified by an affidavit of an authorized person, and upon receipt of a request, the lending bank or secured creditor is mandatorily bound to proceed in terms of the framework and to constitute a committee to identify the incipient stress in the account. So in this event, Lordship, what has been held by the Honorable Supreme Court in the latest judgment, and this also clarifies the stand of pronate, which is the subsequent paragraph, Lordship, in paragraph 8. Pronates is a decision of the coordinate bench of this court holding inter alia that notification is binding on the lending banks or secured creditors. Finding to the contrary by High Court of Bombay in the judgment, and order under challenge in the appeal was thus quashed. Though while stressing that the terms of the framework need to be followed by lending banks or secured creditors before the account of an MSME is classified as NPA, this decision also lays stress on the obligation of the MSMEs by holding that it would be equally incumbent on the part of the MSMEs concerned to be vigilant enough to follow the process laid down under the said framework and bring to the notice of banks concerned by producing authenticated and verifiable documents material to show its eligibility to get the benefit of the said framework. It was cautioned that if such an enterprise allows the entire process for enforcement of security interest under the Surfacey Act to be over, or it having challenged such an action of the bank concerned in the court of law or tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for throttling the actions under the Surfacey Act by raising the plea of being an MSME at a belated stage. This decision, however, left unsaid something which we have explained herein above while construing the terms consistently to prevent undermining of rights that one central enactment confers by another. So this judgment, Lordship, most respectfully clarifies what has been stated in the Pronate's judgment, and in this writ petition, Lordship will kindly take up page 91, that is the 13(3)(a). Not a single whisper in this representation that they are an MSME, nowhere. Thereafter, there is the order of the Honorable Tribunal. The Surfacey application has been moved by them on several other grounds, but there has never been any challenge to the borrower being an MSME or entitled or eligible under any guidelines. Lordship, the representation has been replied by the bank. This representation does not, I have checked up, does not contain a single whisper that I am an MSME and I am entitled to an benefit. And this last judgment,
even the writ petition, there is nothing mentioned with regard to MSME.
No, nothing. This is just an afterthought on the basis of pronates, but subsequently this judgment has come in the to clarify what Pronate has left unsaid.
No, Pronate did say that
yes,
has to be knowledge.
And I followed your Lordship's judgment. Lordship was equally on this point that it is also their obligation and it is not. But this in unequivocal terms is now clarified by the Honorable Supreme Court, just so that there can be no further, Lordship, the litigants are trying to put this pronates to thwart the actions of the bank. So this is just a subsequent thought, and attempt to expand the scope of the writ petition. There is no prayer for any declaration of the NPA being wrong, and the tribunal has already passed an order rejecting their application. And Lordship, today the bank is, my instructions are
Taking possession.
yes,
Very well.
already in the process of
All
taking
right.
possession.
The 13.3a, did you disclose yourself as MSME anywhere in the entire petition
I'm
submission?
Lord, firstly, with regard to
You only rely upon
No.
that document?
I'll just no, I'll show that. But firstly, this judgment comes in July 2020, 8th of July 2025. So this clarification could not have been the bank's understanding of the
No,
whatever. We'll just have a look at page 93, paragraph 6, which is a part of my representation to 13.2. It's specifically mentioned here. Now that I'm an MSME is to the bank's knowledge. Bank itself.
No, but then you should.
I'll just show paragraph 6 kindly see.
That there is
It is pertinent to mention here that it is well within the knowledge of the bank that the Reserve Bank of India, I'm sorry, not page
Yes,
93.
it's all right.
It is pertinent to mention here that it is well within the knowledge of the bank that the Reserve Bank of India has time to time issued various guidelines in order to extend the benefit to likewise businesses, like my client, in order to formulate a scheme for the survival of these industries. Is
No, but
as
then
specific as this.
Very omnibus.
No, Mulad,
Where
the word
is it
MSME is
mentioned?
not there.
Yes.
That comes in July 2025. But Mulad, I'm referring to a scheme.
No, even
I'm
then.
referring to revival. The bank ought to have been aware of its own circulars.
You approach the appellate tribunal. Please come now. I'm not interfering at all. Come.
But then
Supplementary
may I just pray
affidavit
for one thing, Mulad?
filed on
Lordship will
behalf
allow
of
me
the
to take
petitioner.
this plea before the tribunal.
If it was not there before the debts recovery tribunal, you will raise new issues before the appellate forum. It cannot be.
This is on a point
No,
of
no,
law.
it cannot be done. If it is on the point of law, you go and urge. I am not stopping you either. Supplementary affidavit is taken on record. Stop. Learned counsel representing the petitioner stresses upon the fact that the petitioner is an MSME and the bank, being aware of the said fact, ought to have taken steps for revival of the same and ought not to have declared the account as NPA in complete violation of the guidelines of the Reserve Bank of India relating to micro, small and medium enterprises. Stop paragraph. The learned advocate for the petitioner stresses on the ratio laid down by this court, by the Honorable Division Bench of this court, in the matter of State Bank of India versus SRC Steels Private Limited, spelling, reported in 2014 SEC Online Cal. And the judgment delivered by the Honorable Supreme Court in the matter of Pronits versus Board of Directors of Canara Bank and others, reported in 2024 10 SCC 292, wherein the court has held that it is mandatory on the part of the banks to follow the instructions / guidelines, directions issued by the central government and the Reserve Bank of India with regard to the framework for revival and rehabilitation of MSMEs. Stop. The court also held that it would be equally incumbent on the part of the MSME concerned to be vigilant enough to follow the process laid down under the framework and bring to the notice of the bank concerned, by producing authenticated and verifiable documents / material to show its eligibility to get the benefit of the said framework. Stop paragraph. The specific stand is that the loan amount was granted by the bank, taking note of the fact that the petitioner is an MSME. Stop. That being the position, comma, the bank ought to have considered the status of the petitioner and thereafter taken steps in the matter. Stop. Learned advocate representing the bank submits that the fact that the petitioner is trying to highlight the issue of MSME is an afterthought. Stop. In the entire writ petition, there is no mention of the aforesaid fact. Stop. Neither before the tribunal the issue of MSME has been raised. Stop. Learned advocate of the bank relies on the judgment delivered by the Honorable Supreme Court in the matter of takedown reported in 2025 SCC Online SC 1566, which took note of the judgment delivered by the Honorable Supreme Court in pronits within bracket supra. Stop. Next. It has been brought to the notice of the court that the bank is taking possession of the secured asset today. Stop. Next. Upon hearing the parties, it appears that the petitioner already approached the Debts Recovery Tribunal under the Surfacey Act and being unsuccessful has directly approached this court under Article 226 of the Constitution. Stop. The order passed by the Debts Recovery Tribunal is appealable before the appellate forum. Stop. It will be open for the petitioner to approach the appellate forum in accordance with law, if so advised. Stop. Writ petition stands dismissed.
Lordship, my submission that no affidavits have been exchanged, Lordship, that
as the writ petition is disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted.
Lord, may I just pray for one thing?
Yes.
28th August, my Surfacey application is kept for hearing. In the meantime, let them not take physical possession of
it
my
has been
property.
taken. It's already been
Says today it is being taken.
Pass an order, they
See,
will
the
not-
tribunal has the authority to return back possession to you.
What happens, your Lordship has seen 28th is set for final hearing.
You approach the authority.
Physical possession. Well, symbolic is anyway.
It has been taken. She says that it is being taken.
I have
Physical
seen
possession.
That, yes, they're
Taken.
taking. Executive magistrate is there. They're taking possession. That is.
But there is a Passover matter. There is a Passover matter. Will you?
Instruction to accept the.
You can accept the brief. All right. Give a copy. None appears on behalf of the Union of India and the
Time may be given.
No,
and
no,
the
they'll finalize the tender.
Northeast Frontier Railway stuff. RDS also, will you appear? Possibly yes, because it's under the Ministry of Railways.
Mr. India.
So it will be. You can take step.
Union of India is a
Instruction.
party in the proceeding.
Yes, yes, yes. Union is a party. Ministry of Railways is also a party. So RDSO, you can always take instruction. Achha. Let a copy of the writ petition be served upon Mr.
Has been served.
A copy of the writ petition has been
Taken.
served. Your name, please.
Shubhankar Chakraborty.
And naam ta likhen in. Upon such and such learned advocate who is present in court and who usually represents the Union of India before this court. Stop. Mr. Chakraborty will take necessary instruction in the matter. The earliest
tomorrow, tomorrow, not be able to get instruction.
Twice we
Day after tomorrow?
Day after tomorrow, I'll not be there. Next week, any day.
Then, my lord, I don't mind. But
7
in the
days.
meantime, let them not finalize the tender. They're using my drawing and give it to everybody. Your lordship would have passed the order on the last occasion because no one was
Today also nobody is there.
thrice we've served, my lord. Let them not finalize the tender. Let him come back next week. In the meantime, let them not finalize the tender, my lord. This is not at any fault of mine here.
My lord, kindly do not pass any order in this.
Let him give the my lord, otherwise
He doesn't know what the matter is. The court has just thrust upon the
I don't
brief
want to
on
put him in a situation here.
Yes.
But kindly record the thrice have served hand service we've done. They've chosen not to appear. My drawings are going to be given out today, my lord. If they let them not finalize the tender. This much your lordship will give me till they come back.
The date of the tender was?
No, they have not finalized. They've not finalized the techno whatever situation because I'm not participating. I don't
That
know.
means finalized tender means what? The tender has not been floated.
Tender has been floated.
Yes.
The work order has been given. It has not been issued as yet.
The date of the tender 9th May and 9th April 25.
So it's long gone.
No, my lord, it's nothing. I came to know on 22nd of July.
Yes, you may have come.
And nothing has happened because the techno-commercial bid has not, my lord, no work order has been issued as yet. Kindly record my submission if they come and say no has been issued. Kindly record it. And prayer G, your lordship will kindly grant me. Let him come back. My whole issue is my propriety.
He'll look into all the prayers.
Anyway,
He'll look into all the
then
prayers.
lordship will at least lay the hands on finalizing the
Learned advocate for the petitioner submits that the work order has not been issued till date. Stop paragraph. It is expected that till the next date of hearing, the work order is not issued. Stop. Issued by the authority. In that case, I keep it on Tuesday, next Tuesday, 19th.
What about Wednesday, my lord?
Acha 20th. 20th.
Very grateful.
Item 64, my lord has kept it for that matter. My lord.
Oh, yes, 115. Is there other side there?
I have intimated.
Mr. Sen, are you aware what happened? Did the medical examination take place?
Today it had taken place.
Today? Then we have to wait. You tell, I'll put it in the list at the top tomorrow.
I'm for the Union of India.
Janabu? In
the list, but with our understanding, it should be.
It will be taken up at 1:15. At the top tomorrow. Urgent motion at 1:15. Marked at 1:15. You intimate Mr. Sen also. Let's see what happens. Yes, sir.
And possibly he will be taking time, lad.
Who will be taking time?
Item of 14, my lord.
Yes.
My lord was is to direct to file an affidavit, my lord.
Hmm.
And we have already communicated to the concerned body, my lord. Seeking 7 days time, my lord. It is ready, otherwise, I'll come back with an affidavit, my lord. This is the instruction.
Record and order. Learned advocate, give me the file once. Learned advocate representing the Union of India seeks extension of time for filing the affidavit.
Report in the form of an affidavit.
Acha, report in the form of affidavit. Oh, the changes in the Aadhaar card.
Yes. Bank is also there.
I am for the bank.
I beg to be for the Reserve Bank, my lord.
All right. Your appearances. On such submission, release the matter on 26th August. The report shall be circulated by 20th.
Could it kindly be the 27th?
1 minute.
28th.
20th. Today is 12th.
No, 20th.
No, because he has to know what is there. All right, 22nd. 22nd. 22 তারিখ আর ওটাকে রিলিজ 27 করে দিন 27th.
May I mention item number 15, my lord? For the bank, my lord.
Yes.
We think that, my lord, if the matter is not called today, tomorrow and day after I am not there, my lord, kindly accommodate me. And the matter.
Minister চলবে তো?
Lordship.
We've taken up till 14. 15 will be the first matter after recess.
There are some fixed matters also
Where?
at 2 p.m. I thought.
3 p.m. 3 p.m.
My lord, I am.
Item number 58.
Yes.
I better appear from the petitioner. In compliance with the court order, my lord, deposited rupees 8 lakhs within time, but the records those could not reach to the landed advocate in due time, my lord. She could not submit the same, my lord. If you lordship kindly see the deposit slip on the last order, it is stated that within the stipulated time period, it is not deposited. My humble submission before your lordship, the property has been sold, my lord, less than half of the market value, which has been valued by the district register, and 7 lakhs has been taken as an earnestment. And in the meantime, we have paid about 20 lakhs. Now, I am trying before your lordship, kindly allow me some time, my lord, to pay 3 lakhs or 4 lakhs within 2 months, so that I can, my lord, I have no other place to stay, my lord. My wife is ill. She was admitted in the, my lord, AIIMS Kolkata hospital, my lord, for 17 days, my lord.
What has happened before the DRT?
Ready for hearing.
It is pending for hearing.
Ready for hearing.
Meetings are completed.
Yes.
27 November is the date.
All right. And have you taken physical possession?
My lord, we have taken physical possession. There is a stay by the DRT, not to confirm the sale.
All right. You've taken physical possession.
Yes.
No.
So,
Who is,
not to confirm the sale. And my lord,
no. That means the possession is with you now?
No.
You say you've taken physical possession?
No, my lord. No. No, my lord.
No, I do not think, my lord, possession has been taken, my lord.
That means you have not taken physical
Not
possession.
taken physical possession.
The petitioner is in possession still now. All right. What can be done?
My lord, kindly give me some time, my lord, to pay, my lord. 4 lakhs, 4 lakhs, my lord, I shall pay, but they have imposed my penal interest, additional
Oh,
interest.
this is pending before DRT. You make all submissions over there.
My lord, kindly protect the petitioners, my lord, so that, my lord, they do not become homeless because of the fact that, my lord, the property has been sold, my lord, less than half of the market value.
Liberty was given to them to approach DRT of 2023. After that payment, my lord, not a single penny has come.
No.
Yes.
From 2020.
Will you accept if he pays?
That was as per order, my lord.
I understand now the petitioner is willing to pay 4 lakh extra. Not extra, maybe over and above what they have paid. Right? Will you accept? How much is the due now?
I have to seek instruction on this.
See, when the Surfacey proceeding is pending, possibly the bank may not accept. Right? Now, if the bank feels that the property cannot be sold, there is stay order.
It has been already sold out in e-auction. 7 lakhs earnest money has been taken.
Sold out?
It is sold out in the 2002, and my lord. 2022, my lord. Less than half
whatever
of the
it is. Now, if a third party right has accrued in the meantime, then what can the court do?
The sale is not completed. Sale is not completed. It is their admission that sale is not completed. The money has been deposited in a lien account.
Please check up whether it can be settled.
My lord, one-time
The
settlement.
petitioner is agreeable for a settlement.
He has retired, my lord, in the meantime, my lord,
All right.
from service.
How much and when will the money be paid?
My lord, 4 lakhs, my lord, within, my lord, before puja, my lord, within 2 months. Within 2 months, I shall pay 4 lakhs, my lord. Kindly, my lord, protect. My lord, I shall pay, but the matter should be adjudicated, my lord.
The matter is before the tribunal fixed in November.
My lord.
Prior to that, if you want any order, you have to make payment.
Yes.
And only after the bank agrees. If the bank is not agreeable, then no question of any. You cannot force the bank to go for a settlement. Please come.
As per Reserve Bank guideline,
Yes.
No, bank will accept only as per Reserve Bank guidelines.
Yes.
Bank can, because the account is already an NPA.
NPA.
It never developed, improved rather.
My lord,
The petitioner seeks a direction upon the, no, the petitioner is, the petitioner intends for a one-time settlement with the bank. Stop. According to the petitioner, the property has been put up for auction at a very meager rate. Stop. The valuation of the property was
about
not
56
properly done. Stop. The petitioner. Paragraph the learned advocate for the bank is directed to take instruction whether there is any, whether the bank is inclined for a one-time settlement. Inclined for a one-time settlement. Stop. If the bank is agreeable to a settlement, comma, then the amount required to be paid by the petitioner. Stop. উপরে একটা লাইন এই জায়গাটাতে লিখবেন যে the petitioner, paragraph, the learned advocate for the petitioner submits that the petitioner has retired in the meantime. Who has retired? Petitioner number 1.
my lord, one, my lord.
Petitioner number 1 has retired in the meantime, and his wife is suffering from various ailments. Stop. The petitioners do not have any other place to stay, and the secured asset is their residential property. তারপরে ব্যাংকের সাবমিশন ঠিক আছে how soon can you come back? Next week? Next Tuesday?
1 week's time.
Next Tuesday? Very well. List 19th.
Oh, not on Tuesday, but on Wednesday.
20th.
Wednesday or Thursday.
20th.
Much of that. I'm good.
Item number 16.
Sir. Yes.
আসুন
ভয় দেখাচ্ছ কেন? Before I open the case, my lord, there is a can, my lord, which is pending.
It has been filed by you?
Yes.
All right.
Now,
what is the prayer in the can?
my lord, taking exception to, I shall give your lordship, my lord, very briefly the background, and then I shall go into the facts, my lord.
My lord, before my landed senior
Is it
start,
only for the 1 minute? Is it only for disposal of the can that you are making submission, or with regard to the writ
I
petition?
was only wondering, my lord, in the can they have not filed any affidavit. If they do not want to file an affidavit to the can, my lord, it's a different.
Was there any direction for filing affidavit?
No.
No.
Oh, I see. No.
Then
No.
where is the question?
I'm
of-
sorry, my lord. I'm sorry, my lord.
Yes. What is it?
My lord, only one thing will before my landed friend start, my lord. I have a principal point of maintaining the writ petition itself.
All right.
My lord.
What is the writ petition about?
My lord, I will tell your lordship, my lord. The petitioner before your lordship is the owner of a plot of land, my lord, in my lord, the Thakurpukur area.
All right.
Now, the petitioner was developing the property, the land after obtaining the requisite permissions, the plan from the panchayat, the fire license, the BSNL clearance, everything. Now, dispute arose, my lord, because other, my lord, adjacent plots were being developed by other companies. Now, the respondents, my lord, want to contend that, my lord, I have to take an environment clearance. Now, according to us, my lord, the petitioner's land is below the required limit. So, my lord, no environment clearance is required. The plan, as I have submitted, it's, my lord, so far as this plot is concerned, the plot of the petitioner, that is, the constructed area would be less than, my lord, 20,000 square feet, which is over which, my lord, the clearance is required. It's below that, 18,000 square feet.
I am not going into the other plots. Those are also, my lord, from their documents, it would appear that they are also, the other plots are also similarly situated.
Other plots means how many
The
plots?
adjacent plots, my lord.
By somebody else?
Yes. Other
So you are concerned with 18,000?
My plot, yes.
18,000.
Yes. Now, what they are saying, my lord, the pollution, the respondents are saying, my lord, that all these plots are to be clubbed together.
Plots are to be clubbed together?
Yes, for obtaining clearance.
But you say that the plots belong to somebody else, or
yes,
and it's being developed separately?
Separately, after obtaining separate plans, clearance, etc.
All right.
Now, this is the difficulty. Now, when the writ petition was moved, my lord, an order was passed by a coordinate bench,
yes,
directing, my lord, Pollution Control Board, my lord, to consider my application, my lord, for obtaining environment clearance.
All right.
Now, I, my lord, made the requisite application. The order which was passed is again, my lord, they have clubbed everything together.
All right.
Taking exception to that order, my lord, my can is there. Oh, yes. This is state level impact assessment committee. Madam.
I see your prayer is regarding cancellation of the stop work notice.
They have
2023.
I'll tell you, Lordship, my lord, this example, if I remember it correctly, I also gave before the other bench. Now, my lord, they say the entire area has been, my lord, described as Gem City.
Who has described it?
My lord, the owners have described it, the entire area.
Yes.
Now, I said that, my lord, if, my lord, 10 lawyers buy plots of land which are, my lord, contiguous, adjacent to each other, my lord, and they, my lord, start building their own properties, and they, my lord, describe the entire area as lawyers' city. My lord, would that make a singular property? My lord, in my respectful submission, the answer has to be in the negative.
All right.
That is exactly what has been done here.
All right. And all the plots, they are no way connected with each other.
No.
Owners are separate.
Owners are separate.
There are separate sanction letters and everything.
Absolutely.
And Gem City, how did everybody join together to form this Gem City?
There is no formation, my lord. That's the whole difficulty. They have named it, my lord. There is possibly
How this naming was made? No legal.
No, Gem City is not a legal entity. I could have understood then also, my lord, that Gem City is a legal entity.
All right. The impugned order, please place.
Yes. My lord, in the
exception.
Exception, my lord.
Yes.
Kindly give me a step. Can one, my lord, kindly come to page 63?
Yes.
Or before that, my lord, kindly once. Kindly once come to, my lord, page 53.
Yes.
This is the order which was passed in the writ petition. Learned counsel for the petitioner proposes that the respondent number 3, being the SIA, be directed to consider the environment clearance only for zircon, that is, my lord, the project of the petitioner, before your lordship, with a total built-up area of 18,940 square feet, as indicated in an inspection report of 14th September 2021. Learned counsel for the respondent number 3 on instruction submits that the petitioner may be given leave to apply before the respondent number 3 in respect of zircon, having the project detailed and described in the inspection report dated 14 September 2021 with a total built-up area of such and such. After hearing counsel for the parties, as an interim measure, the respondent number 3 is directed to consider the application of the petitioner number 1 only in respect of zircon as per the inspection report of 14 September 2021 for environment clearance if such application is made by the petitioner number 1 within 7 days. Now, my lord, this application is made, my lord. There is no dispute about that. Kindly come to now page 63.
Yes.
This is, my lord, the order which was uploaded in the website. My lord, before that we wrote several letters. We were not aware that it was uploaded in the website. SIA received a written submission from Bhuturia on 27 February 2023 based on the order of the Honorable High Court in WPA number such and such. The project proponent, Bhuturia Construction Private Limited, was requested to appear before SIA for a hearing. Meanwhile, the project proponent applied for environment clearance.
Lordship, may I interrupt for a moment? I have to go to court number 8. I'll just come back.
Who are you representing?
May I?
SPCB, just.
Are
I'll
you
s-
adding any affidavit to this?
SPCB.
Respondent number 5, Your Lordship.
All right.
Yes. I'm just coming in 5 minutes. My
All
matter
right.
has been called. Just let me ask you.
Are you filing any affidavit? না তাহলে
Yes.
তুমি যে সময় নষ্ট করে লাভ নেই।
But then did you challenge this?
Yes, this is the can.
In a can you challenge the order?
My lord,
In
the
a
writ
connected
petition was kept
application?
pending. I have
Yes,
taken,
but then
exception to this.
But don't you think that the scope of the writ petition will be expanded by if this order is permitted to be impugned in the can?
My lord, this
I
was
can see the writ petition pending.
This was, yes, this was on the basis of the order passed in the writ petition. The writ petition, my lord, the order said that consider application of zircon. Now, what they do is, my lord, of their own mix up all. They don't consider zircon only. So, my lord, the order of the writ court, my lord, was not complied with. I shall place before your lordship the entire order, my lord, if required.
Yes.
Your lordship will find that, my lord, they have mixed up all 4 or all 5, whatever it is, all 3. All 3. And, my lord, they have proceeded on the basis. They have not, my lord, complied with the order.
Who is representing 3, 4?
He is representing.
I'm 2 to 4. I am there.
2 to 4, you are there. What is your objection with regard to the maintainability?
My lord, kindly takes up the prayer first.
Prayer in the writ petition.
Prayer in the writ petition.
Yes.
Page 39 of the writ petition.
Yes.
Prayer A.
Have
you got it, Lord?
Hmm.
Writ amendment was direct commanding the respondent authorities to recall, rescind or cancel the stop work notices such and such, being number such and such in annexure P9 and P11. Kindly come to P9. That is page 103 of the writ petition.
Yes.
They have prayed for cancellation of P9 and P11. P9 has been, may I place your lordship, to the GMCT such and such regarding project namely GMCT.
Yes.
Sir, the first paragraph, the second paragraph. Therefore, you are directed to stop all works within the project area immediately under Section 5 of the Environment Protection 1986. Their notice has been issued in pursuance of the Section 5 of the Environment Protection Act, my lord.
So
And
you say it should go before the Green
5A
Tribunal.
provides for appeal.
Green Tribunal, there is.
My lord, 5A, I can show, my lord.
Yes.
5A provides for appeal. My lord, কেটে দিন তো একটু। এই ফ্ল্যাগটা খুলে দেবেন। ওই ফ্ল্যাগটা খুলে দেবেন। Appeal to the National Green Tribunal, my lord. Any person aggrieved by action issued under Section 5 on or commencement of the Green Tribunal may file an
Whether
appeal.
you could have invoked Section 5 of the Act is the question. The
But
appeal
if
court
we have wrongly even, my lord,
certainly
applied, it will
look
be
into
the
it.
question before the appellate authority,
Yes, you can certainly go and.
my lord. And my lord, the also National Green Tribunal Act says, my lord, any dispute pertaining to this will be dealt with by the Green Tribunal.
Well, I shall be very candid. I did not come prepared for this, but I would only humbly submit before your lordship that, my lord, an order within jurisdiction, my lord, appeal has to be there. An order which is without jurisdiction, admittedly, my lord, below 20,000, my lord, it cannot.
But this the appellate court can decide. Why trouble the writ court?
Question is, my lord, whether, my lord, I have writ court, my lord, always, my lord, continues to have jurisdiction, my lord. There is no
Over everything under the sun.
No, not
anything and everything. Writ court.
I do not say that.
Marital disputes before the writ court.
I do not say that. No, kindly don't take
No,
it.
but then I am getting it.
No.
This is what I am saying. Marital disputes before the writ court.
I do not.
Custody.
Custody, right to
I was there.
information, everything is coming. Yesterday you were there.
I do not go that far, my lord. That dispute passed, my lord, within jurisdiction, my lord, wrongly passed, yes. But a jurisdiction invoked wrongly, or, my lord, beyond the scope of the act, my lord, that possibly writ court can come, my lord, in aid of the complaint.
Since an issue of maintainability has been raised, if you want to come prepared, I can adjourn.
Kindly.
Because I see the
Very
under the Environment Protection Act, the National Green Tribunal Act, it should go there. Section 5 of the Environment Protection Act. Please come. Yes. Steps taken by the state level environment impact assessment authority. Under the provisions of the Environment within bracket Protection Act, 1986. Is impugned in the instant writ petition. Stop. A preliminary objection with regard to the maintainability of the writ petition before this court has been raised by the learned advocate representing the respondent numbers 1 to 4.
2 to 4, my lord.
Achha, 2 to 4.
One is the Union of India.
2 to 4. Next. The learned senior counsel representing the petitioner seeks time to come prepared. Stuff. When? Next Tuesday?
Monday.
Monday?
Can it be Monday or Wednesday?
Wednesday? 20th.
And, my lord, do I take it that they are not filing any affidavit to the CAN?
Why are you pressing for it?
No, I am
if your
not.
writ petition
I'm
is not maintainable, then the CAN automatically goes.
And, my lord, if, my lord, I can satisfy your lordship that the petition
Then
is
we will
maintained.
seek for filing affidavits.
That is exactly why I was saying. If they want to, my lord, file affidavit, they
Why disclose their stand here? They will not disclose their defense. They will go and disclose it over there.
Very grateful.
For the petitioner, your lordship, pursuant to your lordship, last direction, the record of the case has been found right by the court of the learned district judge. The petitioner was called upon. The petitioner.
Last question I filed report, my lord.
Yes, yes. The petitioner was called upon by the office of the learned district judge. He has
Your
taken
grievance is
inspection.
redressed.
Yes, sir.
Learned advocate for the petitioner submits that the grievance of the petitioners has been redressed. In view of such submission, the writ petition stands disposed of.
Gratefully touch.
সিটি কোর্ট থেকে রেকর্ডটা এখনো বার করতে পারছি না
Next.
কতক্ষণ লাগলো
The time to take instruction, my lord. I have instruction that my client petitioners told me that some person, the territory manager, Mr. Kaushik Das, contacted him personally and asked for some documents, and they have gave a long list to provide them to prepare a draft deed of lease, my lord. And by this time, for your kind information, my lord, they have not released not yet any penny for.
Principally settled. Kindly adjourn this matter.
No, my lord, lordship will not adjourn this.
Otherwise,
Enough. No. Lordship will kindly take up the memorandum of meeting I produced before your lordship on the last occasion. Everything is settled and signed. Now they will have to demonstrate they are the owners. And proper documents, payment will come after that. We do not know whom we are paying.
Very well,
all their names are
the
recorded, and that will take at least 3 to 4. No, at least 3 to 4 months. Lordship will, and that will give a further cause of action, my lord. My lord, and Lordship will also kindly record that parties have agreed to this, and we are not pressing at this moment the question of maintainability, and that is left open, my lord, because this should not be taken as a precedent in other matters also, because there are similar matters coming before
out
this.
of court settlement, how can it be a precedent?
No, in other matters, my lord, writ petitions are maintainable. Those have been filed.
You raise objection as and when matters are filed?
Lordship will just indicate that, my lord, Lordship has not gone into the issue of maintainability and kindly dispose of this.
Not the
So the
payment
learned
terms have to be
advocate
decided.
representing the
Payment for
oil company asserts that the matter has been settled in between the parties, learned advocate representing the petitioners submits that the process of settlement is still on. Stop. Next. Prayer has been made by the petitioners to adjourn the matter for the time being. Stop. Paragraph. The parties are directed to take further instruction. Stop. Hearing of the writ petition stands adjourned till
Lordship
10th
will kindly
November.
dispose it of, my lord.
It is petitioner's prayer. He
My lord,
says that the
my lord,
matter has not been
my
settled.
lord,
What can
unless
be
they
done?
prove their title, the lease cannot be executed.
Different. That is different.
Well, this settlement can never be reached, my lord.
Whatever.
Lordship
In
is,
that case, the matter has to be heard out.
Lordship will then kindly hear me on the issue of maintainability, my
All
lord.
right. The issue of maintainability as raised by the respondents is left open to be decided at the time of final hearing of the writ petition.
When Lordship is keeping this, my lord, kindly.
It's in November.
Great 50 Lordship.
You said it will take 2 or 3 months.
At least 3 months, because they have not produced a single document of title, my lord.
Very
We
good.
do not know whom we are.
Who to pay?
Yes, who to pay, who will execute the lease. Then no litigation certificate, no mortgage certificate, all are to be produced, my
When the
lord.
terms have been settled, they can always ease it out.
Next.
My lord, I am for the petitioner one. My lord, last occasion on 8 July 2025, your lordship directed the respondent authority to trace out the missing volume and missing book.
Yes.
My lord, over telephone, my lord, on last Friday, my lord, at afternoon, the authority informed to visit the office, my lord. My lord,
You could not.
I could not.
My lord,
at the afternoon, my lord, I have to come to from Dhoniakhali, my lord. So, my lord, next week I shall visit the office of the.
I can remember previous there too also you did not go.
No.
This time also you did not go.
Last occasion I visited as per their direction. But over telephone, my lord, last.
Not
I
only
did
over
just-
telephone, but email was.
No.
No, I'm only.
What does this say? What does this say?
My lord, I'm pursuant to your lordship direction,
Yes.
7th, my lord, we have, my lord, filed a report that volume number 19 was, my lord, not traceable. Your lordship directed to trace out the file and, my lord, intimate the petitioner. Accordingly, it has been traced out and intimated the petitioner.
So it has been traced out. All right. Did not turn up. All right. Please come.
I shall go and.
A report by the Registrar of Assurances, Kolkata, signed on 11th August 2025, placed in court today, is written with the records. Stuff. It appears therefrom that the. Oh, you have made photocopy and you have brought it. Acha. With the report.
Photocopy of the first page.
Copy of the first page of volume number 19, book number 4 for the year 1992 has been annexed. Stop. Copy of the report has been handed over to the learned advocate for the petitioner. Stop. It will be open for the petitioner to cause inspection of the same. Stop. I adjourn it.
Yes, ma'am.
Till 26th, fortnight's time. In the meantime, inspect and come back. Inspection shall be conducted prior to the adjourned date. So 26th, I'll dispose it off. Yes.
20. My lord, on the last occasion, My lord was kind enough, my lord, to ask me to file a report in the matter of my consideration of that letter of agro industries regarding that, my lord, the balance GST, whatever the excess amount GST. Now, my lord, immediately, just my lord, half an hour before, my lord, over telephone, my lord, I talked to the person concerned. My lord, a request, my lord, made so that I can pray before your lordship another 1 week time. Another 1 week time, because it is under consideration of the DM. Kindly give me 1 week time, my lord. And this is the last time. I shall come on the next day, any day.
This is the last
I
time
know.
you cannot assure. You will depend upon instruction.
That is true, but very, my lord, on the half an hour prior, my lord, that over telephone I talked to.
Prayer has been made by the learned advocate representing the state respondents to seek extension of time for filing for production of the reply
Yes.
of the communication dated 30th October 2024.
30th, no.
30th October
October.
Yes, 30th October 2024.
Stop করুন। October 24. Stop. On such submission, release the matter on 26th August.
Get.
Submission.
Get.
I'm for the state respondent.
Yes.
That is, Lordship. My lord, I'm for the petitioner before Lordship. My lord, last occasion, your Lordship directed me to serve add party, my lord, the RTO and the district magistrate of Bankura as a party respondent. I did, your Lordship. I served also. My lord, I think they received also a copy of the
You must be having instructions.
on 8th.
No, it has to be because the DM will be represented by you only. Nobody else.
1 week after
1 week. He is losing money every day, every moment. His property is being depreciated in value. Please come.
I have been through the order also, my lord. It's no reason being given why they rejected my application.
Learned advocate representing the petitioner submits that copy of the writ petition
Yes,
has been served upon the district magistrate and the regional transport authority Bankura. Stop. Learned advocate for the state respondent seeks time to take instruction. Stop. On such prayer released on 19th of August, next Tuesday.
Obliged, Lordship.
My lord, I am for the petitioner led by Mr. Jantanan Chatterjee. My lord, tomorrow is the date fixed for hearing before the State Legal Services Authority. As the
Instruction, I am representing XLSA Lordship. The victim applied for compensation Lordship, enhancement
on 8 July.
Speaks Lordship. If your Lordship kindly fix the matter in fast.
Please come. It has been submitted by the learned advocate for the petitioner and the learned advocate representing SLSA that the petitioner has applied for enhancement of compensation and the date of hearing has been fixed tomorrow. Stop. Prayer has been made to adjourn the writ petition for the time being. Stop. In view of such submission, hearing of the writ petition stands adjourned till how long will you take?
First week of September, Lordship.
First week, 2nd September.
I'm grateful, Lordship.
এটাকে রেকর্ডে রাখবেন।
My lord, I am appearing for the petitioner.
Yes.
My lord, on the last occasion, my learned friend has submitted some document from the PF authority with a serious allegation on my client of committing fraud, my lord. In that situation, my lord, I am seeking leave to file a supplementary affidavit clarifying the total fact of the case and showing how my client is still continuing as a director, and exiting from the PF account does not mean resigning or retirement from the company, my lord. And the only condition which was there in the insurance policy was not to leave the company, my lord. May I file, my lord?
No, but then after the person retires, does he
My lord,
still?
he has not retired. He has only exited from the PF account, my lord, and there was a order of
How can he exit from the
liquidation.
PF
Because, my
account?
lord, the liquidation, the company has gone into liquidation, and the PF account contribution has been stopped. So
Yes.
after that, no contribution was being made for anybody, including my client, who, being the director, has continued in the suspended board after the liquidation also, and still continuing as the director in the board, my lord. And he has not left the company or given any resignation to the board or the liquidator, my lord. To show all these facts, my lord, I need to file a supplementary affidavit, my lord. I'm seeking leave for that.
I'll grant you leave. At the same time, you implead the liquidator as party over here.
My lord.
Otherwise, the company is in liquidation, right?
My lord, the company is in liquidation, and may I file the supplementary affidavit and place some relevant paras, my lord?
Give a copy to him also.
My lord,
Please
we
come.
have sent him a copy,
On the prayer,
a soft copy through email.
on
and I
the
have
prayer
brought the
made
hard
by
copy
the learned advocate for the petitioner to place
before impleading the my
additional
lord.
documents on record.
To show the
A supplementary affidavit has been prepared. Stop. Let the same be taken on record. Stop. Copy of the same has been served upon the learned advocate representing the respondent authority.
My lord, we have already sent him a
But
soft
let it be respondent. We're not also, we're not
As a respondent.
respondent.
Yes.
But the
Yes.
official liquidator has raised a claim. He should be
Well,
added in any. My lordship kindly sees the last occasion. Yes, let him be added.
My lord,
Let
his
him be added.
submission is to be
I'm
countering
But whatever, there are certain, I'll tell your lordship.
of fraud,
Very
my lord.
good.
And this is a serious allegation against my client, which I am countering.
And that allegation remains. Yes.
Affidavit.
The allegation remains.
The conduct of the liquidator.
Yes, that is why he should be brought here.
Now, if you are aggrieved with the act of the liquidator, then
the tribunal.
Not here before for the against the liquidator. Since he has said that the liquidator has a claim, I can show from the records, my lord, this is not the claim to be obtained by the liquidator.
No, that has to be hard in front of before he should be added as a party.
Likuntov, since the company
We have no claim against the liquidator or aggrieved against the liquidator, my lord.
Liquidation, comma, let the official liquidator be formally added as party respondent in the instant writ petition.
Obliged.
Stop. Let a copy of the writ petition be served upon the official liquidator. Stop. Release the matter. Actually, let a copy of the writ petition along with the supplementary affidavit be served upon the added respondent. Release the matter for further consideration on 26th August.
26th August.
Fortnight.
My lord.
Grateful to lordship.
Yes.
My humble submission is, if your lordship will keep it before 22nd August or after 8th September, I am visiting my daughter, my lord.
20. See, today is 12th. Acha, make it on 20th.
20th August. Grateful to lordship.
Only the payment is relates to payment, my lord. The principal amount has been paid, my lord. Only things is that with regard to the interest, my lord. Now they have calculated the interest, my lord, and it is under process, my lord. I was told, my lord, just now, my lord. So, my lord, if some time,
Calculation is under process or
no,
steps
calculation has been done,
thereafter?
and thereafter it has been sent for the health
Vetting.
department for the, my lord, necessary
Vetting.
release.
It's called
Right,
vetting.
my lord, for the release of the payment.
আচ্ছা আসুন দেখি learned advocate representing the state respondent submits that the quantum of interest has already been quantified and the same has been forwarded to the competent authority for vetting and disbursal. Stop. Prayer has been made to adjourn the matter for the time being. Stop. How much? 4 weeks.
I hope, I shall.
He has said me 15 days outside.
No, but I have told, just now, my junior told me it is 4 weeks. I have, I have always trying to, get hold of all these matters, 107 matters, what should you remember? Oh, it's horrible.
Released on 9th of September. It is expected that
Yes, can I record
the
that?
interest shall be paid prior to the adjourned date.
Time for the petition I am praying for not today. Actually, Mr. Amitav Ghosh is leading in this matter. Since he has not come to the court on personal grounds, I am praying for not today.
There was a direction to file the report.
Yes, I will file it. Kindly, make it in any other
May
day.
take the report and thereafter
It has
come back.
It has penetrated the chamber.
It doesn't
Okay.
say so.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned advocate representing the state respondents also seeks accommodation. Now seeks extension of time for filing the report. Stop. In view of such submission, how soon?
Any day.
Next week?
After pujas.
Released on 21st August. Stop. Report shall be prepared and circulated prior to the adjourned date.
21st, kindly,
No.
next or something. 21st, I have a matter.
25th of August.
Let the report.
Deeply obliged. It has come, but I could not print it.
All right.
27, 28, 29. Millard respondent had filed the report. We were to file an exception to that.
Yes.
We filed a.
This is the recovery portion or what?
This is that implementation of.
Yes.
So they had
To file an exception.
We have received
They
the
had filed
application as on
exception,
today,
we
Millard.
filed an
Application.
affidavit for the exception.
Application for what?
Oh, Millard, kindly allow me 2 weeks time, Millard.
You, who are you?
This was for implementation of Mr. Chatterjee was appearing.
Jude board, Millard. Mr. Chatterjee was appearing, Millard. Honorable Mr. Chatterjee.
Yes, I can see counsel standing by your side, behind you.
No, Millard. We all are appearing, Millard.
All for the National Jute Board?
Millard.
Yes. Affidavit by the respondent is taken on record. Seeks time to file an exception. Exception is here.
Exception they have filed. This is my exception, yes.
Yes.
In all the 3 matters.
Right.
Millard, we have to file the reply, Millard. Kindly allow me to file the reply of the said exception, Millard. And 2 weeks time, Millard, kindly be granted, Millard. So that meanwhile, Millard.
What in the meanwhile?
This was for
Why will it remain pending?
Technical calculations. Millard, technical calculations are required to be done, Millard.
the calculations.
We have to
already
deal
there.
with it.
Exception.
No.
They want to rely on the
No,
inspection
no.
report. I am relying on the same document. Well, this was the matter where
It is required to be dealt with. Because the government concerned, Millard.
Payment was directed to be made.
Public.
Yes.
Come and indicate that we'll make the payment. Please give us
Right.
time.
Yes.
Finally, they come and say all payments have been made because under the order, the scheme entitlement under the scheme has been determined and not the amount. We want to file an affidavit. So they file the exception. The exception they are relying on an inspection
Yes.
report. I am relying on the same document.
Where is that report?
No, that report.
Inspection report.
No, that we all, both of us have leave to refer to. That's
No,
a
next-
part of
Inspection report we have annexed in our
the read
reply.
petition. Of the read petition.
Yeah,
That we
Yes.
disclose in my affidavit.
All right. In your affidavit that you filed today,
Yes, ma'am.
inspection of the machinery installed.
So their
Page 11.
specific stand is that, oh, you are entitled to the amount only upon inspection. We have also disclosed the chart in the previous writ petition based on all these inspections. Your Lordship looks at page 17.
Is it your submission that a further inspection is to be done, or inspection is already there? Then what more to be done?
Nothing else is to be done. National Good Court comes up with the engineer's defense that the matter only decided the entitlement and not the amount. I'll be able to show that that's absolutely a frivolous plea. And even if it is there, it's totally barred by constructive res judicata today.
What is to be done? Make payments if it is due.
2 weeks time will be given, my lord. So for the calculation.
I record that within 2 weeks we'll make payment.
No, my lord, calculation part is concerned, my lord. We have to take
Again, calculation. How many times will you calculate?
in the calculation, my lord. So far we need to deal with it.
They've already filed an exception. In that there is nothing.
Only 2 weeks can be considered. Only 2 weeks. I pray before your lord.
Actually, Kunto, reply filed by the petitioner to the exception
My lord.
filed by the National Jute Board is taken on record. Stop Learned Counsel representing the National Jute Board seeks time to take instruction. Released on 26th.
27.
27.
Same matter.
Same order. Are you filing separate replies?
Separate in all three we file.
Yeah, all leading same order.
29.
829.
Obliged.
28, 20.
Madam, I am appealing for the petition. But I sought for an RTI inquiry, my lord. My lord, the earlier direction, my lord, after came.
Yes. Where is your query? Page 24, 29.
You know, you can see what is the query at page number 29.
I'll
29.
I'll say, madam, this is my property. Everything is fine, but I cannot access the same. I cannot access the same. There are deviations made. Only my lord. If tomorrow, my lord, if something extra is found, the notice has to be given to the person responsible. According to records, I'll become the person responsible.
You are the owner. Person responsible may be somebody else who is in occupation.
Notices because
No, let me hear once. Yes.
Well, under the Right to Information Act, he is asking for information at page number 29. Well, in respect of a particular mezzanine floor, the area and all other information he is asking with regard to that. To me, my lord, I can supply the information. There is no difficulty, but it amounts to, according to me, my lord, is an information of private nature. It's a private person's the property.
It is his property. He is the owner.
If his property, he wants to get the information.
Yes, this is the problem. Because he doesn't have an access to it. Is it recorded in your IB? Mezzanine is mezzanine there. So there is no records.
IB, which has been given to me, because IB cannot disclose what is the area and all the other things.
Obviously.
Only the floor, if it's there, then it could be mentioned. Sometimes it is mentioned the total floor, but mezzanine floor, I do not check it up. It is not the I don't find it has been mentioned separately, the mezzanine floor. That is not mentioned.
Petitioner is the owner. The tenant is occupying it. And the tenant is making unauthorized construction. Petitioner does not have an access. He wants to get rid of the tenant. And he wants to ascertain as to what is the unauthorized construction. So he goes through you.
But if he is getting the unauthorized construction, it is the main issue. Then he does not want that information.
You have to advise the petitioner as to how to proceed. On seeing the query, I was sure you will not be able to help because the information that has been sought, you cannot
But
get it.
it can't, it can't help him also.
If he is agreeing to the.
No. Question is, in that way, I cannot supply all the information to the person. If he another construction, of course, I will go to that place and take necessary actions. But this is not the issue here.
I can understand. But then, do you have any information with regard to 285C Bipin Bihari Ganguly Street? Eastern portion, it has been mentioned eastern portion.
In fact, the
First floor side, the way you've made it, it cannot be done.
It is done by the client. I have.
Now you advise him how to move. This I am dismissing.
This is not there.
No, I'm dismissing this. Sir? The petitioner seeks information.
To provide the information.
It's not possible. Seeks information with regard to the carpet area of the newly added mezzanine floor in the eastern side portion of the first floor, roadside room adjoining the veranda at premises number 285C, BB Ganguly Street, Kolkata 12. Learned advocate representing the corporation submits that the aforesaid information is not available with the corporation. Stop next. In view of the above, no relief can be granted to the petitioner in the instant case. Writ petition stands dismissed. Next. Dismissed.
May it please your lordship. I am for the writ petitioner. This is the supplementary affidavit. May I be
supplementary?
Well,
For
there
what
was a
purpose?
direction, because there were subsequent events and there was an inspection. I wanted to bring what happened in the inspection on record and the photographs, comparative photographs. And my lord,
there is so many allegations against the bank, my lord. I want to controvert the same. Otherwise, my lord, they will use this before the DRT also. That will, my lord, bank will prejudice in that case, my lord.
DRT also means any proceeding
Any
pending?
proceeding is pending.
My
My
lord,
lord. Section 19 proceeding is pending
that
against
is
this in
where
that
we came to know that we were implicated and my Aadhaar card and my PAN card was being used
by somebody else.
by somebody
Even
else.
disputed
My lord,
question of fact.
those photographs are there, that the photographs of the applicant as well as my on the same page, they don't tally. If your lordship is pleased enough to come to page
17.
17.
You are the top one or the bottom one?
My lord, neither. My lord, this is me. Bottom, right.
All right. Yes, that
And
means
this is
the
the applicant,
middle
is
one.
the top, second from the top on left. My lord, even the barcode as well as the enrollment number of the Aadhaar do not tally. The enrollment number of the Aadhaar which has been submitted with the bank is supposed to be 14 digits. It's actually 11 digits. My lord, there was a second complaint which we made after the inspection against the chief manager of the Punjab National Bank, that is his client. That is on page 26, annexure P10. Because this entire proceeding started after the mail sent to him with and he wanted our copies of the writ petitioner's copies of the Aadhaar. And that is when the debt recovery proceeding started.
What is the police?
The police is not
investigation.
Twice, I filed report. This is the latest report. And it takes the last page. A soft copy. Last page, page 3.
Yes,
prior to that,
investigation is under
in
progress.
this regard, I submit that during further course of investigation, it has become necessary to examine the bank employees who were engaged in granting the house building credit.
Yes,
As a result, the names of such workers have been collected from the so-and-so bank, and notices under Section 179 of BNSS are being served on them in order to examine for the investigation of this case. Again, the branch manager of the so-and-so bank has been contacted and served a notice under Section 94 of the so-and-so to obtain more information. This is very crucial for the purpose of investigation. Investigation is going on. This is what, latest.
I am not standing any kind of investigation, my lord. Investigation may go on. We have no problem, my lord. The actual culprit, my lord,
Are you taking any coercive steps against this
step has
person
been already taken. Attachment order has been. We have already obtained an attachment order from the
in
DRT.
respect of his property? How can you do now? Because he says
until
there is an identity
after, my lord,
problem.
identity problem is there, my lord. May I, my lord, come back with a short, my lord. I will not controvert that affidavit. I have certain things to say, my lord. I want to place it all those documents to an affidavit, my lord.
Very well.
Otherwise, my lord, I required to
Please
be
come.
controverted. All those allegations, my lord.
Supplementary
Your
affidavit
ladyship,
by the
may I also
petitioner.
have the permission to file a very short reply if at all required?
All right. Supplementary affidavit by the petitioner filed in court is taken on record. Stop. A report by the officer in charge, Topshia Police Station, dated 11th August 25 is also taken on record. Stop. Learned advocate representing the bank seeks time to file a report by way of affidavit. Stop. Next. The bank is directed to prepare a report and file the same by way of an affidavit by 4th September. It will be open for the petitioner to file exception to the same by 19th of September. Release the matter for further consideration on 3rd November 2025.
Lordship, and a copy of the police state's report be.
You want?
Lord.
Give a copy.
Soft copy will be sent.
Yes, yes. Give your number so soft
Lord.
copy will be sent.
Ladyship.
And are you enjoying any interim order or anything?
Well, there's no interim order.
There's no interim order.
Is there any scope for passing an interim order?
There is an additional part I have prayed in this supplementary affidavit that the debt recovery proceeding.
Let us see what will happen.
Yes, yes.
Let's come back. রাখবেন না, পরেরটা রাখুন।
Lordship, in this matter, I am appearing for the respondent number 2, that is Food Corporation of India.
Yes.
I appear for the petitioner. This is that matter which got dismissed for default yesterday. In this matter, the issue is very short. The petitioner before your lordship had entered into an agreement with the union, with the Food Corporation of India for supply of ready-made rice. The rice which are being made, it's called CMR. CMR. Now, I have completed my job. Now, if kindly comes to page 333.43 once. 343.
Yes.
Now, will find they themselves had suggested that a review committee will be formed to redress my grievance. It's a letter of 2021.
Yes.
Now, kindly comes to 344. This is my representation, and I've given my due which has crystallized in excess of I just can't count it, 48 crores maybe. Now, kindly comes to 348. This is my representation in reply.
Yes.
Now, again their letter, I am directed to refer to the above subject, their internal letter, and to enclose here with the minutes of the meeting of VML private player and FCI to discuss on the pending issues of VML with FCI held on such and such and such. Further, FCI is advised that committee constituted by FCI to examine the pending issues of the private players should give fresh opportunity to hear the applicant, that's my client, and then decide the case on merit. All the documents given by the applicant in this department after the above meeting held are forwarded herewith. Now, this is their letter. They are accepting that they want to form the committee. Now, kindly comes to 352. This is my submission of claim. Submission of claim, kindly see, I have quantified my claim at page 353. Now, kindly come to 355. Again, I'm requesting nothing to form the committee so that a right of hearing can be given. That's all. I am only seeking a right of hearing.
Lordship,
so that my issues can be resolved. Nothing more, nothing.
I am having my humble submission before you, my lord. First, I am the respondent number 2. The respondent number 1, kindly have a look, the cost title page. That is Union of India. They are not represented today. Although I am entering into the matter,
I have served.
Challenging all the material allegations. There was a delay.
Listen, the court is not entering into anything.
Yes.
Lordship,
Prayer
I am praying for liberty to file our opposition.
No, sorry, sir.
No, that's only right of hearing.
There
Their letter is there.
A direction for formation of a committee to settle the dispute. Right? Where is this committee? Does the committee exist or not?
That committee was formed, my lord.
Formed. Show me. And what happened? Was the petitioner's case taken into consideration by the committee?
No.
They was ultimately their prayer, their consideration, their application was turned down.
Application, their prayer has been turned down?
Turned down.
Show me.
My lord, it is, I am finding.
And it has been turned down by the committee?
By the committee. But
Show
no,
me.
not by the committee.
By whom?
By the respondent number 2. There
is a direction for a committee. Who are the members of the committee?
Lordship, as I am finding from their records, on January 27, 2021, it is, kindly have a look at paragraph
Has the neutral committee been constituted and has the petitioner's complaint been taken into consideration by the committee?
Complaint?
No, that has not been done.
The petitioner.
I am led by Mr.
Committee
Banerjee.
was formed. Committee was formed. Consideration was taken. But
by the committee?
By the committee. Lordship, it is there from record.
All right. Which page?
Kindly have a look. Paragraph 47 of the writ petition.
Yes.
Page 29.
Yes.
There was finally, by the letter dated January 28, 2021, the respondent corporation released their bank guarantees. And subsequently, my lord, kindly come in paragraph 48.
Yes.
After several representation, the Government of India, the Ministry of Consumer Affairs regarding non-redressal grievances of the petitioner.
Show me the existence of the committee and the fact that the case of the petitioner was considered by the committee.
Lordship, kindly see paragraph 50 in response to the said office memorandum by the office memorandum dated 27th April 2021, Ministry of Law and Justice nominated one Sri Mohendra Khandelwal as one of the nominee for redressal.
Yes, that is page 344. I'm saying that there is no decision.
Committee was formed, but ultimately nothing was held.
Then please come.
সেটাই তো বলছি।
The petitioner has
and another submission is, my lord,
with
the
Food Corporation of India.
Monetary penalty imposed upon them
The
should not be decided here.
Ministry of Consumer Affairs, Food and Public Distribution constituted a committee for redressal of the grievances. Stop. Now, grievances way back in the year 2021-2022. Stop. The committee is yet to take a decision on the grievance of the petitioner. Stop. Several representations were made by the petitioner, praying for a hearing before the neutral committee. Stop. None has been redressed. Stop. Paragraph. None represents the Union of India. Stop. The learned advocate representing the Food Corporation of India submits that the committee was constituted but is not aware as to whether the grievance of the petitioner has been redressed or not. Next. In the absence of the Union of India, the court is not in a position to decide the issue conclusively. Stop next. In view of the above, the instant writ petition is disposed of by directing the Secretary, Department of Food and Public Distribution, Ministry of Consumer Affairs, to take into consideration the prayer of the petitioner for redressal of his grievances by the neutral committee at the earliest, but positively within a period of 4 months from the date of communication of this order. Stop. An opportunity of hearing shall be provided to the petitioner for production of all documents in support of its claim. Petitioners obey. Reasoned order shall
advocates
be
if
passed.
required. Through advocates
Reasoned order
also
shall
if
be passed and communicated to the petitioners. It is made clear that this court has not entered into the merits of the claim of the petitioners, and all points are left open to be decided by the committee after hearing the parties disposed.
May not the parties be represented through their representatives? If my lord kindly provides for that.
Has the authority declined your prayer? You make a prayer. Why should
No.
court
Very
impose?
good. Very good. Grateful to you. Great.
My lord, I am
On pursuant to the Lordship's direction, the report has been filed. and
no, I am yet to file my
petitioner-
report. A copy was handed over.
Yes.
May I be
Your
permitted
Lordship
to file the
kindly give
report?
liberty to file exception.
There's no question of filing an exception. It
Yes,
is
my
only
lord,
the
yes.
facts which has happened, and pursuant to Lordship's direction, I have filed it on, and I wanted to bring it
Do
on
you
record.
not think that this is simply
only a
pendency of the writ
Yes, my
petition?
lord, that's why, my lord, your Lordship kindly see the report of the voluminous report. And my lord, whereas many objection are clubbed together, they have filed.
May I just make one
That's why,
submission?
my lord, your Lordship kindly give liberty to file exception.
My lord, may I just make one submission before your lordship? Pursuant to your lordship's liberty, may I just make one submission?
Yes.
Because if your lordship kindly looks into the prayer of the writ petition, on the last occasion I had highlighted, may I
1
just
minute.
make my
Yes.
submission, my lord? With regard to the prayer which has been sought for against, so far as against Reserve Bank of India is concerned, it is only to reopen a complaint. It is only to reopen a particular complaint and give them an opportunity of being heard. What I had submitted on the previous occasion was that this complaint was closed. Not only that, there were 3 separate complaints which were also dealt with on merit, and they were closed. And to that, my learned friend had raised an objection saying that, no, I'm making the submission from the bar. Actually, that is not the fact. Therefore, it had fallen from your lordship, directing the Reserve Bank of India to file a report in the form of an affidavit. Today, in the form of an affidavit, what I have disclosed is only the 4 complaints which were made to Reserve Bank of India, to the Banking Ombudsman, under 2 different schemes. The 2 different schemes have been annexed to my affidavit. And along with that, the 4 closure complaints, nothing else. And the body of the report would show that only 2 paragraphs are there. Paragraphs which are relevant.
Very well.
It can be, in fact, this
Show me the complaint.
My lord, complaint is, your Lordship kindly see the page 90.
I don't have a copy.
And my lord,
Page 90 is your complaint which has been closed illegally according to you.
yes, my lord, without
Right.
giving any opportunity for hearing, my learned friend has filed the report. The all complaints are clubbed together and.
All right. We will consider the complaint at page 90.
Yes.
Yes. Show me. What is it?
My lord, your Lordship
Pre-closure.
kindly see the complaint, and there is petitioner's name, and my lord, banking name. What are the procedure? And my lord, complaint is, my lord, your Lordship kindly see, we are an MSME unit. Your Lordship kindly see.
The complaint is treated as non-maintainable under clause 9292A.
Yes, sir.
Well, as per their
Why are you aggrieved by this order?
My lord, your lordship, kindly see, their complaint should state clearly the name, address and contact phone at the page 91, their grievance. My lord, your lordship, kindly see the page 90.
Yes.
There. The
Hmm.
name, address, contact, phone number, mobile number, complaint, and my lord, name and address of the branch of the office of the bank, the facts, events, action giving raised to the complaint, all are there. In spite of that, they have grievance that you have no. Thereafter, we have again tried to make complaint, but my lord, the technical glitches, that's why it is not make any complaint.
No, your further complaint would not have helped since your complaint has already been closed.
That's why,
Right.
my lord.
So,
Without giving any opportunity of hearing, they have closed this by way of this.
all right. Now let me see from the
Yes, Your
report.
Lordship, kindly turn to paragraph number 8 of the affidavit, which has been handed over to us.
All separate.
This is paragraph number 8 at
Please
page
wait,
number
my
5.
lord, my lord.
Yes, complaint number is there? Is
Yes,
there
Your
the
Lordship.
complaint number?
Yes.
Two,
Kindly
three,
see,
2.
ending with 362. That
Yes,
is the first
362,
one. Your
yes.
Lordship will find the closure of that at page number 60 of this. And this closure was done on 3rd of February 2021, which is stated also in at page number 5 itself.
No, that has been disclosed by the petitioner at page 91.
Yes, but when was it closed is important. The closure happened on 3rd February 2021. In the closure, if your Lordship will see paragraph number 2 at page number 60, which is also reflected from the writ petition itself.
Yes.
In paragraph number 2, we had in fact held that you may lodge a fresh complaint on the same issue. So liberty was given to the petitioner. Petitioner availed of the option by filing separate complaints on the self-same cause of action after this. So now today, after this was closed and thereafter when they had lodged separate complaints on the self-same cause of action and which were also dealt with, I pose this question to myself: can this be revisited at this stage after closure of 3 subsequent complaints thereafter?
No.
Because
so you say after 3rd February 21, separate complaints were
separate
filed?
complaints were
But
lodged.
there are separate action.
My lord,
That's
may
why,
I be
my lord,
permitted, because as has been
Yes.
submitted,
3rd February 21, after that there were complaints.
there were
filed?
complaints, 3 more complaints after
Yes.
this date. 2 were made under the same scheme of 2006 and the last one was made under the scheme of 2021.
All right.
All of these were dealt with and closed. The last of the complaints were closed on 1st of March 2024. So, your lordship will kindly note the
Is there any scope for granting personal hearing by the ombudsman?
Yes, provided ombudsman deems it necessary, because otherwise your lordship will appreciate there are so many complaints which are received by banking ombudsman. Banking ombudsman, as it receives all the complaints, it calls for the information also from the concerned bank, which is the regulated entity. In this case also, it had asked for the information. Once information is received, it will come to a finding whether at all a hearing is required, or it will forward the response of the regulated entity to the complainant. If the complainant is not satisfied even thereafter with the response of the regulated entity, then if it so deems fit, that hearing would probably change the nature of the course of the outcome, then the hearing is given. Otherwise, it's not mandatory that hearing will be a matter of course, that hearing has to be given, because natural justice is only violated provided they are not being heard out, but they are heard out on the documents which they submit, and both the parties are invited to give their respective response. In this case also, it was availed of, it was done that way.
After closure of the complaint on 3rd February,
Yes, your
show
lordship.
the other complaint.
I will show your lordship all the rest of the complaints. If your lordship now turns to paragraph number 8 once, in tandem, I'll be taking your lordship to the respective closures. After this complaint, which was closed and the closure is at page number 60, your lordship will find the next complaint was closed under 93C of the banking ombudsman scheme, which is at page number 63 of my affidavit, which I have handed over. Your lordship will find there is a reference to another complaint here. which is not the first one. But this was closed prior in point of time. That is why I'm taking a lordship through this first. This was closed on 15th of March, 2021. This was closed on 15th of March, which is also corroborated from page number 7 of the report. If a lordship looks into page number 7 of the report, it is how it was closed by way of mail. So the email correspondence was sent to the petitioner.
All are say.
Then your lordship will look into page number 9, the next closure, which is in reference of page number 66. Kindly looks at page number 66. This is relevant. This is closure of 24th of May 2021, which is the next one.
Yes.
The finding is here that it has not revealed any deficiency in service. The reasoning is given in paragraph number 2. Your lordship will kindly look into here that South Indian Bank submitted its reply as indicated below. So the reply was also communicated to them, the details of it. And then it was said that in view of the above, it is concluded that the submissions made by the bank as well as the complainant in respect of the issue have not revealed deficiency in the service rendered by the bank. We therefore close the complaint under 13(1)(a). So this was on merit how it was dealt with. The third one, and thereafter the fourth one was also
Were
lodged.
the issues same in all the subsequent complaints?
All the same. All the same. Your lordship will take it from me. In fact, that is the reason why the report was called for. Let my learned friend show what was the nature of the
Very well, please come.
report.
Report filed by the respondent numbers 1 and 2 in court is taken on record. Learned advocate for the petitioner seeks time to file exception to the same. Step. Hearing of the writ petition stands adjourned till 9th September. Step. Exception may be prepared and circulated by 29th August.
Grateful.
A copy of the report may be supplied to me.
Yes, yes. Give a copy.
I will forward you.
My lord, I'm for the petitioner. On the last occasion, my lord had directed us to serve a copy of the updated motion. However, my lord, only 2 notices have been delivered as of now, and the rest are pending. My lord kindly fixes it on Wednesday or 20th of August. I hope that they will reach in Delhi. The notices will reach in Delhi by then, my lord.
Who are you representing?
All the respondents.
No, he's representing all. Yes, what is the issue?
My brief, my lord. My lord, this matter is pertaining to one election that was held in the year 2024. This election was for the recognition of the trade unions in the Eastern Railway Zone. There were certain discrepancies, my lord, in the election process. If my lord goes to peruses the final modalities, the elections, they were held on the basis of one modality, being the guideline to conduct those elections. However, the grounds that were violated herein, my lord,
grounds table good.
my lord, annexure P1 is for the authorization letter.
Show me the law where the election dispute is to be resolved. What is the provision for resolution of the election dispute?
Lordship will kindly see, my lord, as per the notice or direction of the railway board for the recognition of the respective my lord, trade unions in the journal basis. So, my lord, a committee was to be formed. That means a notice was given, and all notices were given all the trade unions in the region for the modality where there will be a discussion how the secret ballot will be, my lord.
No, just tell me what is the forum for resolution of dispute relating to election?
None provided, my lord.
My lord, there is nothing.
There
There
was
is no
none
forum.
provided. Sorry, sir.
Only if any dispute is to be, my lord, given in writing to the authorities, stating all why.
Which authority?
Authority, my lord, the committee
the
which
ballot
was
committee.
formed for the conducting election in the secret ballot. That committee was formed. If any grievance is there, my lord, a complaint is to be made through that committee.
My lord, there are two things. Kindly produces Annexure P6, the final
Yeah, my lord,
modalities.
election has been completed, result has been declared, and my lord, the one of the union.
When was the election concluded?
2024 December.
24th of December to 16th of December it was held. Now, my lord, the result.
December. Now you filed this writ petition in April 25.
Yes, my lord.
Why will the writ petition be entertained?
Because I had waited, my lord.
For
Annexure
reason?
P6 is the final modalities.
Page.
Page number, my lord. Unfortunately, my lord, I am unable to carry the physical brief because of my arm.
No, no. If the soft copy is all right, then you can
I
proceed.
have the application, my lord. If my lord gives me even tomorrow, I will come up with the physical brief. I have the page number. I will.
No, no. You have the soft copy with you.
I only have the application, my lord.
You?
The application, the writ petition, the applications, the annexures are. I am unable to access that due to some technical glitch. I am extremely apologetic, my lord. There's some technological glitch. If my lord fixes it tomorrow, my lord.
Learned advocate for the petitioner seeks accommodation. Stop. Released. 26th of August.
Grateful.
6th August. 26th August.
Yeah, ठीक है. Right to note.
Appearance of the Union of India, please provide.
That has been given to people. That's it, sir.
Yes.
But the Learned Council is online. But as per the last direction, affidavit has been submitted.
Yes. What is your grievance?
Yes.
Yes, Manoj. Am I audible?
Yes.
Manoj, the basic contention here is that in 2018, a void marriage was performed between Pallavi Singha and my client, the petitioner. Manoj, in 2019 itself, we applied for the before the trial court for making that for a decree of void marriage, and the same was granted by the honorable court. And thereafter, my lords, in between, I solemnized my second marriage with Monica. The issue here is today is that, my lords, I have solemnized a second marriage. The first marriage was void, and that same has been declared by the honorable trial court. Now what is happening is that the respondents are repeatedly issuing RTI replies, even though which they are not authorized to make. RTI replies stating the marital status, my lords. If they are providing the marriage certificate, that would have been a different issue. But what is happening is that, my lords, as of now, is that they are stating upon the decree, my lords, even though decree has been provided to the respondents, they are saying no, the marriage is not void, and they are making their own, providing their own analysis. My lords, even if it's a Hindu Marriage Act or under Special Marriage Act, my lords, the honorable court has the power to decide the validity of marriage.
Sir,
Or the
I'm
status of
unable to understand your grievance. What exactly is the grievance? The marriage has been set aside by the court. Then what is the problem?
Absolutely. My lords, now what happened is that the RTI reply, which I was mentioning earlier, they take the RTI reply to the other court, other jurisdictional court. There they register different cases, criminal cases. If I, my lords, may allow, my lords, the first
Can I
FIR
just, in short,
is
my
at
lord,
page number 80.
when marriage declared void,
Still, the respondent number 2 and 3 giving reply that marriage is subsisting.
Where is it?
But page number 131, that representation was given. Still, in RTI,
Who has made the RTI application?
My lords,
Who has made the RTI application?
the petitioner had made the application. The reply is at page number 23, my lords. At page number 23, my lords. Sorry, my lords, page number 24. Page number 24, my lords. The 6th line, my lords. Cancellation at this and till date, hence their marital status is married. My lords, this is the reply which I have received. Now the unauthorized reply has also been made, upon which the FIRs and the other cases has been filed. That I can also show, my lords.
May I indicate in short, my lord, what has happened?
Yes, please.
They want an annulment of a certificate of marriage.
Yes.
To us, under the Special Marriage Act, on a different date, a certificate was issued under the Special Marriage Act of a marriage. Now they are asking that to be annulled on the basis of an order which has been passed in a court from Uttar Pradesh, stating that a social marriage under the Hindu Marriage Act has been declared null and void. Well, we have simply stated in page 23, on the basis of the report at page 24, that there is as such, if your lordship kindly takes up 1, 2, 3,
That
4.
means the marriage took place under the Hindu Marriage Act and the registration took place under the Special Marriage
They
Act.
made a registration over here under the Special Marriage Act on a different date. They want that to be annulled on the basis of an order passed in some different date. My lord, kindly have a look at the dates, my lord, also. The order they are pointing it out, page 92. First, let me point it out. Page 92.
Yes.
The very first opening paragraph, ex parte judgment. It was an ex parte judgment, my lord. There it says that this petition has been filed for divorce under section 12 of the Hindu Marriage Act.
Not divorce, annulment.
See, he is reading from the judgment. Please do not interject.
Absolutely, my lords.
Thereafter, the last line of that particular page, my lord. Khala, West Bengal of 21/11/2018.
Right.
Of that date. Now, my lord, thereafter, that has been annulled at page, finally at page 94. It was declared the order. The petition is decreed ex parte. The marriage between the petitioner, Bhaskar Singh, and the opposite party, Pallavi Singh, dated 21st November 2018. Well, kindly note this one, 2018, 21st 11, declared void. Now, at page 23, what we have stated on the basis of a report at page 24, marriage register said that only one registration has been done under the Special Marriage Act on 10th of January 2019, a different date. Therefore, we have replied at page 23, the 5th paragraph. But one marriage certificate includes, lordship got it? Page 23.
Yes.
That's what we have replied. But one marriage certificate enclosed with your application issued to Mohammad Mukhtar, non-marriage official marriage officer under section 13 of the Special Marriage Act, dated 10th of January 2019, has not been declared void or cancelled by the family court. We have expressed that this is a different certificate, different date.
Yes, I got it. Yes, the petitioner, your explanation, please.
Now, my lords, the thing is that the marital status is being repeatedly provided by them. Now, my lords, even if it's a Hindu Marriage Act or Special Marriage Act, my lords, they cannot provide the marital status. They can provide the marriage certificate. That is the only power they have. It is the honorable courts that would decide the marital status of the marriage. That is what is one of my main contention.
The
And my
petition
lords,
is aggrieved by the communication made by the Registrar, Registrar General of Marriages, West Bengal, on 4th March 25, by declaring that the marriage between the petitioner and one Srimati Pallavi Singha solemnized under Section 13 of the Special Marriage Act, 1954 on 10th January 2019 has not been annulled / cancelled by the authority. Stop. The marriage between the parties in accordance with the said act has also not been cancelled or annulled by any court of competent jurisdiction. Stop. Learned advocate for the petitioner submits that the marriage between the petitioner and the said Pallavi Singha stood annulled by an ex parte judgment allegedly passed by the Principal Judge of Family Court, Gautam Buddha Nagar, in matrimonial case number 262/2019 on 23rd May 2022. Stop. Submission is that after the marriage between the parties has been declared void by the court, the Registrar General ought not to declare the petitioner's status with the private respondent as married. Stop. Paragraph. Learned advocate representing the state respondents has taken this court to the judgment dated 23rd May 2022. It appears therefrom that the court declared the marriage between the parties conducted on 21st November 2018, registered under the Hindu Marriage Act 1955 as void. Stop. The Registrar General of Marriages have mentioned about the marriage certificate which was registered on 10th January 2019. Not certificate, the marriage solemnized on 10th January 2019 under the Special Marriage Act 1954 as not annulled / cancelled. Stop. In fact, admittedly, there is no order from any competent court of law declaring the marriage solemnized under the Special Marriage Act on 10th January 2019 as void. Stop. Paragraph. It appears that the petitioner solemnized his marriage with Pallavi Singha on two diverse dates under two separate provisions of law. Stop. One was registered on 21st November 2018 under the Hindu Marriage Act and the other registered on 10th January 2019 under the Special Marriage Act. Stop. The petitioner obtained a declaration from the court that the marriage solemnized under the Hindu Marriage Act stood void. Stop. The petitioner, for reasons best known, did not obtain any order in respect of the marriage solemnized under the Special Marriage Act 1954. Stop. Next, in view of the above, the communication made by the Registrar General of Marriages on 4th March 25 does not call for any interference. The writ petition fails and is hereby dismissed.
My lords, if I may able to show one last document, my lords. Just one document.
Nothing further. You go and register your marriages on two diverse dates under two provisions of law.
No, my lord,
I do
that
not
is
know what is the reason.
regarding that.
Call the next one.
For the municipality. For the municipality.
Municipality.
For the petitioner, Your Lordship, my learned senior is appearing virtually.
Yes.
I'm for the private respondent number 5, Lordship. I just get briefed today only, Lordship. I required few times. Next day I will come with the opposition, Lordship. I want to file the opposition.
Respondent number 5.
Yes, John Rani.
Yes. What is your grievance?
Unmute করতে হবে তো। Unmute.
Court cannot hear you.
Let the
Your Lordship, am I audible?
may I?
Unmute yourself, please. Yes. Raise the volume. Raise the volume a little bit.
Am I audible now, Your Lordship?
ফোনের ভলিউমটাই বোধহয় কমানো আছে।
What is the matter?
But the co-sharers are at loggerheads regarding a firm license under the Drugs and Cosmetics Act. But they are having partition suits amongst them. There are twofold grievances. One, the issuance of the license in the name of the private respondents, as well the issuance of trade license by the municipality. But trade license by the municipality is a far more lower thing. But basic thing is Drugs and Control Act license. So
You
today
are representing whom? The
municipality.
municipality. Who is for the state?
But I found one very important thing. I was just going through the petition. There was some illegible, so I checked up from the Shartak so that I can download the pages. There I found in the nodal officer had put in the instructions of the state, where I found that the deputy director Drugs and Control Act has taken up this issue.
All right.
And unfortunately, but they have not made them a party.
Yes, they ought to have been made a party. The
they are
drug license authority. Otherwise, how can that issue be
Yes,
decided?
in the month of June, there are certain
Is there any prayer with regard to the drug license?
Yes, they have the private respondent has submitted all important documents. These things they are having these documents. The private respondent is having.
No, he says yes. The drug license is also there.
Your Lordship, respondent number 2 has been added. Drug authority, Your Lordship, and this ownership proof is
No, Director of Health and Family Welfare is not the drug licensing authority.
Bug inspector has not been included in as a party respondent, Your Lordship. I
You
At page 60, my lord, he has addressed a representation to the Assistant Director of Drug and Control Office. Perhaps this is an outcome of that. Perhaps I'm not very sure about that. Page 58, Your Lordship would kindly see.
Who will be the competent authority? Director of Drug Control.
The Director of Drugs and Control. But this is the.
Please
I'll
come.
give you. I'm putting the address, my lord.
Leave is granted to the advocate on record of the petitioner to implead the Director of Drugs Control.
Department of Family and Health and Family Welfare, Director of Drugs and Control. That should be the exact.
But the department will be represented by the director.
Yes. They are in CC with the matter.
Achha.
License.
Director of Drugs Control, comma, Department of Health and Family Welfare, comma, Directorate of Drugs Control as party respondent in the instant writ petition.
India Exchange, please.
And serve a copy on the aforesaid respondent. Who is appearing for the state? Did you inquire?
GP office থেকে পায় তো
Yes, we have served them.
না কি GP office থেকে কি
Otherwise you could
perhaps Mr. Dipanjan Dotto in the earlier order your lordship had recorded his name.
Yes, where is he?
They were served.
Shubhajit Chaudhary. Acha. A copy upon the added respondent. ঠিক আছে? Learned advocate representing the state respondents shall come ready with proper instruction from the Director of Drugs Control. Where were you so long?
Might have we have missed the list, my lord.
You've missed it. All right. Take instruction. Release the matter next Tuesday.
Great.
হচ্ছে 19 তারিখ।
এটা আজকে 38 ছিল।
Good.
All 39.
Item number 39.
Madam, I am for the respondent
I got the petition now, my lord.
Yes.
Pursuant to your lordship's direction, my lord, answering respondent is the Punjab National Bank. Yesterday, my lord.
এরপর কল্যাণ কৃষ্ণ নন্দীর মামলা ডাকবেন। Yes.
Answering respondent is the Punjab National Bank, my lord.
I'm for the Union of India, my lord. I'm not the answering respondent, my lord.
Did you serve the Punjab National
Yesterday,
Bank?
my lord, I
Oh, you served yesterday.
because of my learned friend who was suffering in the
All right.
admitted court.
There is no proof of service of the writ petition upon the Punjab National Bank.
Earlier I served, if the service is filed, again my
But
lord.
nobody is there.
In the last occasion, PNB was not there, man.
Yes. ঠিক আছে?
There is no proof of service of the writ petition.
Upon the Punjab National Bank, stop. Let notice be served. Released on next Tuesday, 19th.
Get my নামটা
দিল তো
Question to your APA.
My lord, I'm praying for not today.
Huh?
I'm praying for not today.
Not today? It has been
My lord, I'm appearing for Union of India, my lord.
Sir, gone and you pray for not today?
My lord,
No, my lord, actually,
for the respondent.
my lord, I'm appearing for Union of India. She's my junior, my lord. On the last day, my lord, the petitioners have filed a supplementary affidavit, my lord. I have instructions, my lord, that I need to file an opposition, my lord. So kindly
Oh,
give
that
me,
is your instruction. All
my
right,
lord.
you keep your instruction to yourself. Let me hear, and thereafter we can decide. Where is Pinaki Ranjan
My
Chakraborty?
lord, he is not well, my lord. He is having a heart problem, my lord, today. So he has not come to the court also, my lord.
What problem? Heart problem?
Yes, my lord. There's some cardiac problem, my lord. From yesterday, he's suffering from that problem, my lord.
If there will be a valid claim state, it will be hard work when their availability is very possible. The downgradation has been, initially Lordship was pleased to not stay that, downgradation has been, that downgradation be stayed for the time being.
It was stayed.
It means that we are not incompetent, we are competent, but you are put down from class 4 to class 3.
Yes.
That is not permissible.
Despite an order, interim order, the authorities, though they have taken note of the order, but still they are not permitting the petitioner to put its bid in the higher grade, right? Now the matter has to be decided, or contempt proceedings and everything will arise.
Just to identify the heart finally.
This is the reason the matter has been fixed today.
They have let them not give effect to the downgrading. Which is the order
Not giving effect to the downgrading means you have to be given benefit of the higher class. Right? Now, the authority is not acting.
My lord, we'll satisfy your lordship that they have violated against the contract, my lord. That is why they have been downgraded, my lord.
Very well. So let us start hearing and
My lord, allow us, my lord, time because my senior is also not there, my lord. Within a week, we'll file the reply to the supplementary affidavit filed by the petitioners, my lord.
10 days
And your lordship knows, my lord, I'm led by Mr. Pinaki Ranjan Chatterjee, my lord. He's not well, my lord.
his name recorded in the order sheet, and that is the reason I inquired.
My lord,
Now, if you say there is a cardiac issue,
my
then
lord,
I
this
do
is
not
true,
know.
my lord. This is true, my lord. I cannot submit false things before your lordship, my lord.
Understand. Now, cardiac issue is not viral fever that you take paracetamol and you come to court. You have to understand that. If cardiac issue is there, then it will take some time at least.
My lord, he has informed me, my lord, to pray before your lordship, my lord, at least 1 week time. If 1 week time is granted, my lord, he'll come back before your lordship to address your lordship, my lord.
And how many tenders will be floated within this week?
My lord, your lord, as in terms of your lordship order, my lord, with regard to one tender, we have not taken any decision, my lord. Your lord, we have kept your lordship's order, my lord. We have not taken any decisions, my lord.
And will any other tender be floated within a week?
My lord, that instruction I do not have, but on last occasion, after your lordship was satisfied, your lordship passed this order, my lord, to keep that particular tender process in abeyance, my lord. And we are keeping that tender process in abeyance, my lord.
That shows that this is there is no such against them. Let them not process the further tender procedure till the matter is taken up in 10 days, 12 days, whenever they like.
The tender which the respondents say is not being processed, is it a single tender?
Yes, my lord, the tender number is also mentioned in the order, my lord.
All right. Please come. Even though the matter was fixed in the presence of learned counsels representing both the parties, fixed today in the presence. A prayer for accommodation has been made by the learned advocate representing the respondents. Stuff paragraph. The learned advocate representing the respondent submits that in compliance of the direction passed by the court, the respondents have kept in abeyance all steps in connection with the subject tender process. Stop paragraph. The As accommodation has been sought for by the respondents, accordingly, the respondents are restrained from taking any further steps in respect of the subject tender till 29th August 2025 or until further order, whichever is earlier.
Subject tender, new tender also on the same issue. On the same material.
On the prayer of the respondents, hearing of the writ petition stands adjourned till 19th August 3:30/4 p.m.
My lord, one indulgence, my lord. Liberty may be granted if you want to file any reply to that opposition to that supplementary affidavit filed on the last day by the petitioner.
It will be open for the respondents to file opposition to the supplementary affidavit filed by the petitioners.
I'm grateful, my lord.
Prior to the adjourned date.
Extremely grateful, my lord.
So this is the best that can be done for a week.
But they have said they are not putting the subject tender.
Yes.
It should not go to the father tender for the same issue.
No, then same issue means issue with you is the same. With you is the same, but if they require certain materials or some work, and if the entire tender process is stalled, it's the railway authority. It may not be proper.
Grateful, my lord.
Let us see. If floating and finalization cannot be done in a week.
They will not allow us to participate.
Let us see you participate.
Yes.
And then where you will be considered in the senior class or the lower grade class, I do not know. Let's wait till 19th. Let us see.
Tenders not are floated, I will be allowed to participate, not subject to further order of this court.
All right. In the event tenders are floated by the authority prior to 19th, the petitioners shall be permitted to participate in the same, subject to any order passed by this court in the instant writ petition.
My lord, they can participate subject to their present gradation, my lord, because that will again create, because on last occasion your lordship had heard this, my lord, and your lordship was pleased to only keep that particular subject tender in abeyance, my lord.
Exactly, and that is the reason the matter was fixed today. But
My
today
lord, but
adjournment. So
no, my lord, your lordship will appreciate it. This is under my lord, we could not help it out, my lord. Grateful.